Good afternoon, Professor Krina Bautak, my dear classmates, and all attendees joining us today, both in person and online. It is our privilege to welcome you all to our event, Eastward Looking, International Arbitration in Asia. A few months ago, when we were completing our second semester, we had learned a great deal about international arbitration from our amazing professors here at the School of International Arbitration, Queen Mary University of London. We study leading case law such as Kebabji, Dala Real Estate, or Enga Shop, or Gazprom, and explore best practices from the leading arbitral institutions and seas, such as LCIA in London, STC in Stockholm, and ICC in Paris. These experiences shaped and sharpened our understanding of international arbitration, guided by the best minds in the field. But then, a question came to us. How can what we have learned here be translated into the realities of our own jurisdictions? As lawyers from Asia, we found ourselves wondering whether the established norms and practices developed in the West can capture the phenomena happening at home. Asia's presence in the world cannot be overstated. With a total population of over 4.86 billion, or nearly 60% of the entire global population, and a GDP of 32.6 trillion pounds, being the largest economy in the world, can we discuss international arbitration, or even the word international itself, while leaving Asia out of the picture? With that thoughts in our minds, we decided to take action and organize this event as a platform to bring Asian jurisdictions into perspective. From China, with its ever-expanding presence and formidable domestic market, Hong Kong, an established seat with sophisticated international financial center, Singapore, whose arbitration framework has earned broad international recognition, India, a powerhouse jurisdiction of enormous potential, to Thailand, an emerging yet unique story as a model law country, and to Malaysia, whose evolving arbitration landscape reflects the wider dynamic of the region. And also many other Asian jurisdictions that we would like to present, but not being able to today. Each of us is honored to share with you how international arbitration is taking shape in the places we call home. Most importantly, in a world where the ability to navigate and manage cultural differences has never been more important, we are honored to have Professor Krina Bautak join us today for our fireside chat on a most timely topic, clash of cultures, navigating cultures in arbitration. Professor Krina Bautak is an independent international arbitrator and associate professor of international arbitration and dispute resolution at Queen Mary University of London School of International Arbitration. She acted for over 20 years as counsel, arbitrator, expert, and institutional leader, and has been appointed as arbitrator, both presiding and co-arbitrator, under the rules of leading arbitral institutions such as ICC, LCIA, SIAC, SCC, as well as ad hoc proceedings under arbitral arbitration rules. In addition to her practice, she holds several prominent leadership and governance roles. She's a vice chair of the board of the SCC Arbitration Institute, a council member of the ICC Institute of World Business Law, and director of the Global Diploma in International Commercial Arbitration of the Chartered Institute of Arbitrators. It is our privilege to have her with us today. This conversation, this fireside chat, will be moderated by our charismatic course representative, João Maria Falcao, who brings us a truly global perspective as a bridge between two worlds. João is the course representative of Comparative and International Dispute Resolution Program. He is a Portuguese qualified lawyer with hands-on experience in international arbitration and cross-border litigation. He is also a co-founder of the Portuguese Arbitration Mood Association and member of ICC Young Arbitration and ADR Forum, LCAA Young International Arbitration Group, Young International Council for Commercial Arbitration, and Young Exit. He is also currently production editor at Chartered Institute of Arbitrators in London. Thanks, Joao. We are fortunate to have you with us today. And also, he will moderate a roundtable discussion among our speakers on the theme of the role of national courts in arbitration from the angle of public policy, delving deep into the ever-watchful role of our domestic courts play in the arbitral process. With all that said, let us waste no more time and come be our guests. Let us turn this room in the center of London into our home and allow us to take you on a journey through the places we are proud to call our own. Thank you and welcome all of you. And let me pass the stage to the Fireside Chat discussion.
Well, thank you very much, Sean, for the very kind words. Now I'm a little bit embarrassed, especially because got a presentation like that next to Professor Krina Valtag. It's actually an honor. Yeah, is this the microphone working? Everything is working? Yeah. Do people hear us?
Yeah.
Yes. Okay. So we're going to start, and I'm going to pass it to Esther, who's going to present, start this fireside with the.
Thank you. Thank you, Joe, for your warm introduction, and many thanks to Professor Beltel of joining us for this very interesting topic about navigating the cultural differences in arbitration. I'm sure that both the audience and us are very keen to know from your extensive experience, like across different roles in arbitral proceedings, as to the influence of cultural differences. We're keen firstly to know about, like, when we talk about cultural differences in arbitration proceedings, what does it actually mean to both practitioners and to the other people as well? Thank you.
First of all, congratulations for putting together this event. It's always nice to see students in practicing what we're trying to teach them. And this was a wonderful idea, but also seeing it coming to fruition is absolutely amazing. So well done. I'm honored to be here. And I'm honored to sit with you, especially since throughout the year at Queen Mary, we have different activities outside the classroom, but related to the teaching, including the Vismut competition. So I would start with the culture from a bit one step back. We have to understand what we mean by culture in general. Culture of arbitration, it's a particular type of culture. There is a wonderful book now written by both father and son, but at the origin, Gert Hofstede, who studied cultures, and in particular when it comes to how one negotiates, what the styles of negotiation are. Hofstede started from the basic question, looking at individuals. What are they? First of all, they have the layer of every human being. So we start from a very basic foundation, as human beings. We come with a package that is brought by the simple fact that we're human beings. Then it comes the culture, and I'll get back to that. And on top of that is the personality. And this is what makes each of us unique, because we add these layers. And this is why when you talk about culture, even in arbitration, I would add the nuance that there is the fact that we're individuals, and therefore we have our individual personalities that might alter the culture, even if we assume that we might have the same culture. Then Hofstede went and asked the question, what does culture include? And then you have the set of values, the set of beliefs, the set of heroes to look up to, So there are certain layers when you're looking at culture. But what is culture? And it's very simple. There are different types of culture, and they all add to this big group culture. And on top of that, I was saying personality. And of course, is the culture of a country, the culture of a region, the culture of a specific ethnic group, the culture of different genders, the culture of the school where which you attend, the culture of your family. So all the small cultures put together make up for the culture of an individual. And this is what is interesting, because even if we try to generalize and say in international arbitration, we are so diverse because we come, as in this room and online, we come different cultures sitting together. In fact, it's more than that. It's so unique to each of us. And the beauty of it is that we manage to add the layers of cultures with every experience that we have. The fact that you studied at Queen Mary, that added a new culture. The fact that you're in a new organization, Chartered Institute, it's a organizational culture that would add to your overall culture. So when you go into a hearing in an arbitration, João is not going to be just João from Portugal. You are going to have different layers of culture. So what it means for arbitration. It's interesting because, and we'll probably talk a bit more about this. I think every entrant in the international arbitration will come in, as I said, unique. And in international arbitration, we managed to set certain standards, if one wants to say, to set up our own culture of arbitration. And gradually we tend to adapt to it. But the beautiful part of it is that we still keep a bit of our original culture. Now, it's interesting because in arbitration, I think it's the only it's a book that was published by Professor Von Kidan, and it's about the culture in arbitration, but it's very difficult to and again is important to have the studies, but I think any analysis of the culture of arbitration can only be made in an inclusive way, not limited to culture, not limited to arbitration. The long answer in short. Complex.
Yeah, thank you very much. A very nice introduction of what cultural differences actually mean. Like we have cultural differences across different regions or different countries, and then on top of that, we also have our personal personality, and then from the practice of the arbitral proceedings, we have new cultures and new standards adopted. So that therefore it makes our international arbitration so complex, and put another way, like interesting. But in your experience, what do you think cultural differences are more evidenced during the arbitral proceedings? Thank you.
Well, they're noticeable before you start the arbitration. I think that's the message. Usually you have the pre-arbitration phase, which is negotiation. Invariably, there is an attempt to negotiate that is formalized or not. And I was mentioning Gert Hofstede, but we also have late Professor Salak, who looked at how different cultures try to negotiate. And it's very interesting because it starts from Professor Salaku's project research starts from cultures in the sense of countries. Somebody coming from United States, somebody coming from Japan, somebody coming from Brazil, but then he looked at the actual contract negotiation. So not dispute resolution negotiation, but how actually these cultures negotiate the contract. And it's very interesting to see how, for example, risk averse are some jurisdictions, Coming from some jurisdictions, some appreciate being trusted more, some appreciate easy gain, and so on and so forth. So the way we negotiate, even before arbitration, says a lot, because that has an impact on the arbitration afterwards. You continue to negotiate during arbitration, even if not the merits, you're still negotiating the procedure. So that has an impact on it very much. And in particular, if parties are coming from different cultural backgrounds, and not necessarily you might be in different industries, for example. In the arbitration, of course, the moment you send the request for arbitration, you already put your imprint on how you framed it from a cultural point of view. And that continues. So I think what is important, of course, besides the constitution of the tribunal, which in itself, it's very sensitive to the question of culture, and where personalities also play an important role. So both added layers that Hofstede mentioned. It's very important to understand that the first case management conference, the procedure order number 1, is the point of tension, I would say, in the arbitration, because that's the moment when you're trying to educate the parties in the culture of this arbitration. This is how we are going to proceed. No matter what you said in the request for arbitration, no matter what you did in your pre-arbitration negotiation, mediation, no matter what you did in your contract, this is how this arbitration is going to run. And it's very important for the arbitrators as well to identify this in the PO1, these points of tension that are usually document production, the hearing itself, and how flexible the parties can be in their procedural behavior. So I think you see it in all the moments of the arbitration, but in particular at the beginning of arbitration is going to manifestly affect the rest of the arbitration.
Thank you. Indeed, like cultural differences are manifest across the whole process of arbitral proceedings, not just from the very first beginning, but before that, like starting from negotiation.
Yeah.
Yeah, and Charles, do you have anything?
Yeah, I wanted to say, well, we covered a little bit of a lot of things here, and I think I especially agree. I worked a lot with Lusophone Africa, and it's very interesting to see how different types of jurisdictions or clients. Of course, we cannot exclude the personalities of the people that we work. I think it would be a little bit oversimplifying assumptions, but we see that different cultures is even in the way that because international arbitration, a lot of lawyers are used to contact directly with the courts, and the court systems also have a little bit of a cultural
Elements inside there.
Exactly. So it actually manifests a little bit, or they bring that baggage to the international arbitration. So when you select arbitrator, as we're saying, of course, a party would feel more comfortable to select an arbitrator whose cultural values are more inclined to theirs, because they want also to have their co-arbitrator to have a little bit of knowledge about how's the business conduct maybe in their culture. So it's very interesting. I think we're going to move on a little bit to the case conduct and termination, like Professor Baltag was asking. And I actually wanted to ask you if there's any specific, for example, any example of situations of cultural expectations that kind of shaped, and maybe get into also a little bit of the rules that parties choose, because we have, especially in the document production, we have the IBA rules on taking out the evidence that were very influenced by common law system. And the civil lawyers created the Prague rules. but we don't see them as much applied as the common law at all. Exactly. So I wanted to ask, is also this type of, how do cultural balance, cultural challenges in these rules also manifest, and if some of them actually take over and seem more fit in international arbitration?
No, I asked Mundi AI last night in how many arbitrations the Prague rules were used, and the answer was none in our database. So I think it's important to have initiatives, and in particular the IBA coming with the proposal of in particular the arbitration committee coming with a proposal to have these rules and guidelines that will help us navigate an international arbitration using a common language is very important. There are, of course, there are different layers in your question, and of course the answer. One starts from the seat of arbitration, which I think is important, and this has a significant impact on the choice of the parties of implementing this common denominator, this common language in arbitration. Some institutions or some arbitration laws, because they wanted to ensure that the seat is attractive for arbitration, or not even attractive to arbitration, but trying to retain the existing arbitration, have actively pursued standards that are of international arbitration. They're example of arbitration rules of very regional or domestic arbitration institutions that include in their provisions the reference to the IBA rules on the taking of evidence. And this is significant. So we're not looking at major arbitration institutions, but rather small, which are trying to make arbitration more international, standardized. Let's put it this way. It is important in arbitration for the parties to, as I said, to speak the same language of the proceedings. It is not mandatory for the arbitral tribunal to impose this on the parties. It is not mandatory for the parties to even select these rules or guidelines, be it of the Chartered Institute of Arbitrators or of the IBA or the Prague rules and so on. They can be guided by these instruments. The guidance, it's in itself, I believe, sufficient to ensure that everybody at the table is understanding the concepts, is understanding the way the concepts are implemented in practice. And this is very significant because you might have legal cultures that don't recognize certain institutions. Prague rules, that's why, document production, civil law jurisdictions, how can you produce evidence against you? So it is not just, I want this arbitration to, all international arbitrations to look the same, and we all conduct ourselves in the same way, but also to educate the cultures that you have at the table, because you might not have those legal concepts in your own legal culture. There are various examples, but I think important is the educational side that arbitration brings at the table when it comes to the legal culture. And you see this cross-fertilization. We're talking, of course, a lot about security for costs. Security for costs in civil law jurisdictions is something that you don't really know what it is. And it took about 9 years for the Swedish courts to actually enforce a security for costs. Although in the arbitration rules of the SEC was implemented in 2017. This is a cross-fertilization coming of arbitration and litigation, coming from arbitration. You establish a new institution, legal institution, in a civil law country that was not having that. Other examples are the antecedent anti-arbitration injunctions. So we see the strong resistance of the EU countries when it came to antecedent injunctions, which the English courts have routinely implemented. Now you have a complete openness to antecedent anti-arbitration injunctions. So it's very important for us to understand it's not just instruments that are trying to impose this common language, but we are actually, our arbitration culture is influencing the general legal culture. I talk too much.
No. It's very interesting to know about that.
We're skipping all the questions because
that's very good to know about, like, from the civil law perspective, like how they face maybe that would be disadvantage to them in the middle of the arbitral proceedings. But we talked about we need legal education, etc. We understand that, yes, of course, that would be a way to improve, maybe to balance the civil law and the common law jurisdiction, especially under the context of arbitral proceedings. But I can imagine that at some point that would become a tension in the arbitral hearing. So would that be a trouble, or would that be a problem as you maybe when sitting as a tribunal to decide the dispute, when facing maybe there would be cohorts from different legal traditions, or maybe from councils from different legal traditions? Would that be a trouble to you to decide on the matter? Or in what ways would you navigate or to balance with this kind of differences when you are sitting as a tribunal?
This reminded me of an arbitration I had some years ago, and also a hearing. And you're talking about understanding you're talking about the Lusophone Africa and the fact that you understand the language. But what is more important is to come, not necessarily to come from that culture, but at least to have experienced that culture closely by living in that culture, to understand the nuances, to understand the gestures, to be able to have the right reactions to the specific circumstance. And I remember of this arbitration because the parties were from the same jurisdiction. The tribunal, the three members of the tribunal were not, only one was from the jurisdiction of the parties, the other two were not. I was chairing, I was not from the jurisdiction of the parties, but I lived in that jurisdiction. And it was very interesting at the hearing, one of the other foreign arbitrator said, but they're fighting now. And I said, no, they're not fighting. This is the way they're discussing, because they're trying to find the dates or whatever it was in there. And I said, they're not fighting. This is how they're discussing. And it was very important because somebody else in that moment would have intervened and reacted, but for them, it was the normal process of negotiating whatever date was in question. And at the end of the hearing, actually, the parties came and said it was very good to have a chair that understands the culture. And there were other examples in that arbitration that helped. But I think one point, of course, is not just the parties that have to pay attention to the tribunal, and some adjust their advocacy to the tribunal, and that includes the culture. But also the tribunal to pay attention to the parties, in particular when they're not coming from the same jurisdiction. The fact that you speak the language is one element of the culture that you need to understand. And if something, as a tribunal, something that is culturally related prevents you from deciding the case, then perhaps you have to put a bit more effort as an arbitrator, or at least be mindful and open to be able to address the issue, to be able to properly understand it in that context. Yeah, very, very interesting. I have other stories about culture. and we're talking about Asia. It's very interesting when you're changing the regions. It's a way that, for example, witnesses behave in a cross-examination in Asia, and that very much depends on the jurisdiction, and it's different how witnesses behave, for example, in Brazil. And in between, you have the Middle East and the Europe. It's fascinating, and it's important to sit across different institutions because you experience this layer of culture, and as an arbitrator, it's very important to be able to focus on the case rather focusing on the advocacy, which may be influenced by the culture.
Yeah. Well, I just want to say thank you. This is a very nice talk about how culture and the importance. We had this question of what would be your advice for junior lawyers that are now starting their careers on it. I think you kind of already replied a little bit about.
I have some other ideas as well.
But, so go.
Well, I think it's important to remember that there are many participants in the arbitration world. And it starts, of course, counsel, they have their role. Counsel, very important, less parties, but of course, with the help of the parties are the ones selecting the arbitrators. So they have a very significant role. And through their participation in the procedure, they will be the first ones to be able to set a common denominator, a common language for the arbitration. Then we have, of course, the arbitrators, and their duty is self-awareness to understand where they are, in what arbitration, how they have to behave, but also to be able to manage the process effectively. And we have the arbitration institutions, and the arbitration institutions nowadays are very much responsible not just for administering an arbitration, but also for educating the users and also for setting standards. So of course, we have other participants that I will not mention all of them now, including experts, third-party funders, so on and so forth. But for the new entrants in the profession, I think it's important to experience all these cultures, or at least one, maybe later the arbitrator, but definitely one significant experience interacting with this, one of the cultures of arbitration that comes at the table, because that gives you the 360 view on arbitration, be it as counsel, be it as an in-house counsel, being as counseling an arbitration institution, or why not with the Chartered Institute of Arbitrators, with the IBA, and so on and so forth. When it comes to culture, it's very important, because we're saying that language is one thing, being from that culture or experience the culture on site is also important. And this is why we're talking about diversity. This is why the diversity matters, and it's diversity in all its forms. It's important for the parties to know that they are heard and understood in all forms and shapes. And this is why we need to acknowledge that cultural diversity is very important. So being here in London, coming to study here, being in a room with so many different cultures is already an advantage when you go to arbitration. Other ideas is to continue organizing this type of events even after you graduate, because it's important to talk openly about such interesting topics. Thank you.
Thank you very much for a very interesting sharing with us, and we did learn a lot of it. I think we have still time for maybe one.
It's almost 3, but Professor.
Professor will be open to all I think, yeah, maybe because like we have already like covered a lot and substantively as to different areas of cultural differences in arbitral proceedings. So maybe have a big plus to our professors for their very good.
Thank you for moderating.
Yeah, so yeah, because of the time, then we can maybe we need to move to another section, and we apologize that we don't have enough time for the Q&A section for the moment. Yeah, thank you.
Thank you, everyone. So that was the fireside chat. And now we are going to have jurisdictional presentations from students from each jurisdiction from China, Hong Kong, Singapore, India, and Thailand. And then we have a roundtable discussion. So first, welcome Miss Sophie from China, who present about China. And thank you so much, Professor Kina. And also, please feel free to purchase some drinks and some food, some wine.
Okay. Good afternoon, everyone, from online and on-site. My name is Shouping Liu, and you can also call me Sophia. And I'm a CIDR student from Queen Mary University of London. And I'm also the international arbitration student from Shenzhen University in China. It is my great honor to have the opportunity to represent mainland China to share with you some insights of the recent developments of international arbitration in mainland China. So my topic today is global standard local innovation, and I will mainly focus on how mainland China converge with international standards, by the same time keep its own Chinese characteristics. So I will divide my part into 4 main parts. The first part, I would like to give you a clear understanding of how the recent developments of international arbitration in mainland China nowadays. And the second part is the spotlight of our revision of the new arbitration law. The third part is the relationship between the courts and the arbitration. The last part is the interaction among 4 different jurisdictions in mainland. So coming to our first part, the statistics. So according to the data from the Ministry of Justice Press Conference 2025, by the end of August 2025, there are about 285 arbitration institutions across China. And the overall cases is that over 5 million, with a total dispute amount over RMB 9 trillion. It is approximately GBP 1 trillion. And the parties involving in those cases are more than 100 countries and regions around the world. So here's the table regarding the 4 major arbitration institutions there in China, which is CTAC, SCIA, Shenzhen Court of International Arbitration, BAC or BIAC, Beijing International Arbitration Center, and Shanghai International Arbitration Center. So we can see the amount. In 2025, the number of cases in each arbitration institution are more than 5,000 cases. You can see the SCIA is total cases achieve 40,000 cases. And as for the total dispute amount, almost most arbitration institutions are over 100 billion RMB. As for the number of the foreign related arbitration cases, most of them are more than 300 cases. Maybe it is not so clear for you to have this amount in mind. So let me show you some comparison with LCIA and ICC. According to the official statistics of LCIA 2024, you can see that the total cases in LCIA is about 362. And in ICC 2024, the total arbitration cases is about 841. So this statistic shows that the China's arbitration industry has entered into a period of rigorous developments, and the large number of the case law enable the arbitration institution in China to develop their case management ability, and also a good chance for the arbitrators and even the legal practitioners to improve their practical skills. And most importantly, it can directly enhance the overall strength and the growing influence of China's arbitration. So this study shows that we do have the ability and capacity to handle no matter the domestic arbitration cases and also the international and foreign related arbitration cases. So the rapid development of international arbitration in China is inseparable from its legal basis. So let's dive in the spotlights of the revision of PRC arbitration law. So our new arbitration law came into effect on 2026, March the 1st. So as for the first spotlight, it is our first time to formally include the implied recognition of the validity of arbitration agreements, which means that if one party claims the existence of arbitration agreement when applying for arbitration, but the other party doesn't raise any objection before the first hearing, and also if the whole process, the tribunal has already made notification to both parties and make a recording, that it means that there exists the arbitration agreement between both parties by the implicit way. So the new inclusion of this article means that from the institutional law level, that we recognize the implied method of the existence of arbitration agreement. The second spotlight is we formally established the principle of competent competence. Before that, as for our previous arbitration law, the power of deciding whether the tribunal has the jurisdiction of the present case belongs to the arbitration commission, which is the arbitration institution, and the court is not belongs to the tribunal. So the new law changed this situation in order to converge with the global standards. The third spotlight is the development of interim methods. The first difference from the previous arbitration law is that we have already broadened the scope of the interim method, that is from the property preservation, evidence preservation to the conduct preservation. But both the pre-arbitration relief and the post-arbitration relief, the power to grant the interim method all belongs to the courts instead of the tribunal. But nowadays, the major arbitration institutions like CTAC, BAC, SCIA, or SHIAC have already made exploratory arrangement of granting the interim method in their arbitration rules. For example, here's a new cases that released by BAC in 2025. It is mainland China's first tribunal issue interim method. Although most arbitration institutions grant the power to the tribunal to issue the interim method, it doesn't mean that it has the enforceability. As we said before, only the court has the power to grant the enforceable interim method. So it means that the tribunal could only issue the decision of the interim method, but its enforceability, the power of its ability should be issued by the courts finally. And the fourth spotlight is the recognition of ad hoc arbitration. So the difference from China and the other jurisdiction, we are beginning with the institutional arbitration instead of ad hoc arbitration based on our history and the situation of the whole country. So from the revision of the new arbitration law, we began to includes the ad hoc arbitration, but it limited into the specific case type. For example, the first case type is the foreign-related maritime disputes, and the second one is the foreign-related dispute between the enterprises established within the free trade zone or ports, which includes Hainan, Shanghai, and so on. And if both parties need to select China as the seat of arbitration, and for the ad hoc tribunal, that we also have a record filing mechanism, which means that the tribunal shall timely complete the record filing with the arbitration association, and the scope of the record filing includes parties' name, the seat of arbitration, the composition of arbitral tribunal, and the arbitration rules, in order to supervise the whole proceedings of the ad hoc arbitration by the arbitration commission. The fifth spotlight is that we formally include the concept of the seat of arbitration. Although in the practice area and also the interpretation of the arbitration law, we already have the concept of the seat of arbitration. But beside it, we also have the concept of the domicile of arbitration institution, which means that before the new arbitration law, the concept that we replace for the seat of arbitration is domicile of arbitration institution. So in order to align with the global standards, we change this situation. So we don't use the concept of domicile of arbitration institution. We use the seats of arbitration to put it in our arbitration law. So here's the cases of how we did before the inclusion of the concept of the seat of arbitration. So from the first cases which was rendered in 2004, the Supreme Court at that time held that since the ICC is an institution that established in France, so the cases that we rendered by the award rendered in Hong Kong constitute a French award. But the opinions of the Supreme Court changed in 2010, which shows that although the ICC is a French institution, since the award is rendered in Singapore, so it is a Singaporean award instead of the French award. So in practice, we have already used the seats of arbitration, but in the institutional level, we haven't put it in our law. So that's the change. So the new developments is inseparable from the legal system, but also inseparable from how the court treats arbitration, and what's the attitudes of the court towards arbitration. So what's the relationship between court and arbitration in mainland China? Here we go. So here's the status from the Supreme Court's annual reports on judicial review of commercial arbitration in 2024. Is the latest statistics was released at the end of 2025. So the courts nationwide concluded a total amount of more than 80,000 cases involving the judicial review, and the judicial review includes the review of the validity of arbitration agreements, set aside the arbitral award, the recognition and enforcement of foreign arbitration award, and also refuse enforcement of arbitral award. And within the cases of the setting aside arbitral award, you can see the rates. There are only 2.22% cases resulted in full or partial allotments. And as for the application of recognition and enforcement of foreign arbitration awards in 2024, there's no foreign award was delaying by the courts in mainland China. So So feel free to choose China as the seats and also recognize and enforce the arbitral award in China as long as it match the provision of New York Convention. Most China's courts will agree to recognize and enforce it. So the court's attitudes towards arbitration is supportive. We are pro-arbitration in mainland China. So let me show you. As for our judicial review, we have our own mechanism, that is the reporting and review mechanism. So let me show you the flow chart to make you have a clear understanding of our mechanism. So we have 4 levels of the courts in mainland China. The first level is the primary court, the second is the intermediate court, and then high court and the Supreme Court. But only the intermediate court has the right to make a judicial review of the arbitration cases. So if the intermediate court intends to invalidate the arbitration agreement or refuse enforcement or even set aside the award, that the court need to report to the high court. If the high court keep agreed with the lower court's refusal, that the high court need to report the case to the Supreme Court. If the Supreme Court approve the refusal, okay, that the intermediate court has the right to invalidate the AA, refuse enforcement or set aside the award. And here, let me show you that what I share with you is the flow of how this mechanism works. So next, let me show you the consideration for the courts to take into account when they make the judicial review. So here's the first cases is avoided in 2012, that the lower courts wants to equal the unfair arbitral outcomes to a violation of China's public policy, but the Supreme Court explicitly held that the unfair arbitral outcome is not equal to a violation of China's public policy. And the China's public policy means that it is a violation of the fundamental principle of PRC law or infringement of the national sovereignty and endanger of the state and public security or breach the good moral. So that's the definition of the public policy and what's the consideration that the courts will take into account when they have a judicial review. And as for the second cases, the Supreme Court also have that have a definition of this public policy and also have that a violation of mandatory provision of PRC domestic law cannot be automatically equal to the violation of public policy as long as it does not prejudice the fundamental public policy. So the public policy is the most important consideration when the courts doing the judicial review. So here's is the website from the Supreme Court that annually the Supreme Court will release the judicial interpretation and binding cases or even the model cases for the legal practitioner to know how the judicial review work in mainland China. The last part is the interaction among 4 different jurisdictions in China. We all know that based on the history in China nowadays, we have 4 different jurisdictions in one country, that is Hong Kong SAR, which is common law system, Macau SAR, which is civil law system, and Taiwan region, which is civil law system. And mainland China is also civil law system. So in order to make the award be recognized and enforced smoothly, and also for the enforcement of the interim method, between mainland China and the SAR, we have some arrangements. So due to the time limitation, I will only focus on the arrangement between mainland China and Hong Kong SAR. So the first one is the arrangement concerning the mutual enforcement of arbitral awards. And the second one is the arrangement concerning mutual assistance in court order interim method. I will put much more attention on the second one arrangement because it is the first time for mainland China to issue an arrangement providing interim method in other jurisdiction, which means that if your clients choose the seats in mainland China or Hong Kong SAR or Macau SAR, if the other party has assets in one of them, that it is easier for you to apply for interim method in those jurisdictions. But if you set a seat in Singapore or London or Paris, you cannot ask the mainland China or the SAR to issue an interim method. So that's the system that we call the inter-regional judicial assistance. Yeah, so that comes to the end of my presentation. So the journey of the mainland China comes to an end. To make a conclusion, China's recent development are not just about the growing number and statistics. More importantly, it reflects the institutional innovation and the deeply rooted pro-arbitration judicial environment. So by bridging global standards with its own China's characteristics, China is building a more predictable, transparent, and resilient hub for international dispute resolution. And also at the international arbitration stage, I have to say that Chinese voice cannot be ignored anymore, and we are deserved to be heard. So thank you so much for your time to listen to my presentation. And if you have any questions, feel free to ask me now or after the event. Thank you. So now, please give a warm welcome to my colleague to share the Hong Kong SAR's arbitration process to you. Thank you.
So hello everyone, I'm Esther Liu. I'm a Hong Kong qualified solicitor, and I'm also qualified in England and Wales, but I primarily did commercial litigation back then in Hong Kong. So today I'm also a CIDR LLM student together with my co-ed as well. So today I would like to present you with the topic of the interplay between insolvency proceedings and arbitration agreements. The reason why I'd like to present you with this topic is because there has been very interesting development in case law in this area, not just in Hong Kong, but in other jurisdictions such as England and Wales and Singapore. So maybe in future, when your client will come to you and ask you like, oh, I have Hong Kong targeted company, I want to wind it up, but that the petition that is subject to an arbitration agreement, how could I deal with that? Maybe today's presentation could help you a little bit about that, and that's why I chose to present this topic to you. So the core question of today's presentation is that when the petition that is subject to an arbitration agreement, for the court views this that differently from those petitions that is not subject to an arbitration agreement. In today's presentation, I will first briefly introduce you with the basic principles of insolvency in Hong Kong, and then I will walk you through the development in case law in respect of the petition that's subject to arbitration agreement. And then finally, I will wrap it up with a little bit introduction of the law in England and Wales and Singapore. So firstly, we put aside the complexity from arbitration agreement. The basic principle of insolvency in Hong Kong is that bona fide dispute on substantial grounds. That means the debtor must show a genuine substantiated basis for the dispute. Like, for example, when the creditor presents a winding up petition to the company's court, the company would say, oh no, you are not entitled to a winding up order because I don't really owe you the money. I have genuine dispute over the debt and I have evidence to back it up. And that is bona fide dispute on substantial grounds. Before I move further as to the development in case law, I would like to note to you that winding up petition or bankruptcy petition are not falling within Section 20 of the Arbitration Ordinance in Hong Kong, mirroring Article 8 of the Model Law. According to Section 20 of the Arbitration Ordinance, a court before which an action is brought in the matter which is a subject of an arbitration agreement shall refer the parties to arbitration unless it finds that the agreement is null and void, inoperative, or incapable of being performed. Because the bankruptcy or winding up petitions are not the subject matter of an arbitration agreement, rather the underlying agreement or the underlying transaction are the subject matter of the arbitration agreement. Therefore, a stay of the petition is not warranted by virtue of the Section 20 Arbitration Ordinance. So what really matters is the exercise of discretion of the court as to see whether or not to stay or dismiss the winding up or bankruptcy petition. So at the end, that's the exercise of discretion. And now we come to the development of the case law. Before all the recent case law development, the answer is simple, which is that the petition that's subject to arbitration agreement is no different from those that are not subject to it. So at the end, that is still the bona fide dispute on substantial ground test. But now it has been changed following the Lasmus case, which the court departed from the previous Hong Kong case law and followed the English approach in several states. So in the Lasmus case, it concerns a management service agreement with HAIAC arbitration clause. The petitioner petitioned for winding up against the company, and the company applied to strike out the winding up petition. In coming to the court's conclusion, the main concern of the court is the policy consideration of the Hong Kong court being strongly supportive of the development of arbitration and the policy underlying the arbitration ordinance. And by asking the court to consider or to decide the bona fide dispute on substantial ground of the petition, that is no different to asking the court to conduct a merit assessment over the debt in a summary judgment fashion. But parties have already agreed that the dispute shall be, for example, referred to arbitration for dispute resolution. So if the court decides the bona fide dispute on substantial ground over the petition, that would disregard the policy consideration of the arbitration ordinance. So in the Lasmus case, the court of first instance said, no, in this situation, the test would be different. So how different it is? The court held that the winding up petition shall be generally dismissed if, firstly, the company dispute the petition debt. Secondly, the contract contains an arbitration clause covering any dispute relating to the debt. And thirdly, the company has taken steps to commence the contractually mandated dispute resolution process and filed an affirmation to the company's court to show that. Notably, this Lasmus case did not receive a very popular treatment in the cases afterwards. It was not uniformly followed at the FI level, and even the Court of Appeal has expressed the reservation towards this Lasmus approach. He commented in his obiter that even though the Lasmus approach may not be regarded as totally precluding a creditor from invoking the insolvency jurisdiction of the court, it is a substantial curtailment of his statutory right. So by now, the Hong Kong position is still unclear as to how to deal with the petition that's subject to arbitration agreement. And then the situation becomes clearer following the Regatta Homeland case at Court of Final Appeal, which is the highest court in the Hong Kong judicial systems, and the cases afterwards. In the Regatta Homeland case, it was a petition of bankruptcy against Mr. Lam, but a subject that was containing an exclusive jurisdiction clause in favor of the New York courts. Mr. Lam opposed the petition relying on the EJC. In first instance, the bankruptcy order was granted, but in the later appeal of Mr. Lam to Court of Appeal and then to Court of Final Appeal, in both Courts of Appeals found in favor of Mr. Lam. But in the Court of Final Appeals decision, it held that as long as the defense to the debt is not completely frivolous, which amounts to abuse of process, and they call it a threshold consideration, the court will have the room to exercise the discretion to account for the public policy of giving effect to the parties agreed dispute resolution forum. Notably, this is not the only public policy concern of the court in exercising the discretion. Like, for example, if the creditors' community would be at risk, if the petition would be stayed, or if there is an obviously insubstantial grounds for disputing the debt, those are also the public policy consideration of the court in exercising the discretion. So in the Regaika Homeland case, the Court of Final Appeal laid down a multifactorial approach in dealing with these situations, which is that in the ordinary case of an EJC, absent countervailing factors such as the risk of insolvency affecting third parties and a dispute that borders on frivolous or abuse of process, the petitioner and the debtor ought to be held to their contract. There are 2 points I would like to note to you in respect of this multifactorial approach. First point is that an EJC does not automatically prevent a winding up factors, orders. There are also other like countervailing factors the court would take into account. Also, merits of the underlying dispute remains relevant even in this multifactorial framework. For example, when considering whether or not the defense would borders on frivolous or abuse of process. But the Regaika Homeland case was concerning EJC situation. How about an arbitration agreement? That was discussed in the Resimplicity case. In that case, the company failed to pay under corporate guarantee and bond instruments, both subject to HKIAC arbitration clause. The winding up petition was presented, a first instance winding up order was made, and then the company appealed. The core question in this case is whether or not the multifactorial approach as laid down in Regaika Homeland case would apply equally on an arbitration agreement situation. The court said yes. The Court of Appeal analyzed the reasoning of the Regaika case and said that the same reasoning could apply equally in an arbitration agreement situation. Therefore, the multifactorial approach in the Regaika case could extend to an arbitration agreement situation as well. The Court of Appeal also noted that the countervailing factors as listed in the Regaika case are non-exhaustive. Therefore, the court still retains a great flexibility in exercising the discretion. One of the countervailing factors as newly introduced, or I don't say newly introduced, should be say that is reaffirmed, is the third condition in the last most case, which is that the company should take a genuine steps to commence arbitration, etc. But it is not an onerous requirement as commented by the Court of Appeal. Taking steps to the preliminary stage of the arbitration could suffice. And even if the company has not taken that steps, the court could still has the power to grant a short adjournment to the parties to do so upon their undertaking. So we have now covered a situation that the Regaika approach of multifactorial framework applied to arbitration agreement. Now we come to a different situation of cross-claim, which is that the arbitration agreement is in respect of the cross-claim, but not the petition debt itself. That's the situation in the Rishandong Chenmin case, where the petition debt is based on an unsatisfied arbitral award, but the company argued on the basis of the cross-claim that the amount of the cross-claim actually exceeds the petition debt. And the cross-claim, which is breach of the joint venture agreement, that contains an HKIAC arbitration clause. The Court of Appeal held that there is no, and confirmed that there is no difference in principle between cross-claim and dispute on the petition debt following the English practice. And same reasoning will apply that where the court is asked to consider the genuineness of the cross-claim, yet the cross-claim contains an HKIAC or arbitration agreement, and the policy concern of Hong Kong court to respect parties' agreement would click in. Therefore, the Court of Appeal in the Rishandong Chenmin case held that the Regaika Homeland multifactorial framework will apply to a cross-claim situation as well. Also, it commented that there is a safety valve in the Regaika approach, which is that rule will be displaced where the dispute borders on the frivolous or abuse of process. Therefore, merit is still relevant. And also, the Court of Appeal noted that the delay in putting forth a cross-claim might be treated as abuse of process as well. So we should not sit still and do nothing. Now we have covered situations where the re-guideline multifactorial approach will apply in cross-claim. Now we turn to a different context, which is anti-suit injunction. In Harvard Communication Group case, the Cayman Island company guaranteed a loan under HK-IAC arbitration agreement. After default, the lender served a statutory demand in Cayman Islands and would like to commence a winding up petition against the company in Cayman Islands. The company applied for a quasi-timid anti-suit injunction in Hong Kong court to restrain the foreign winding up proceedings. Notably, the subject arbitration clause writes, any dispute, controversy, or claim arising in any way out of or in connection with the agreement shall be referred to and finally resolved by binding arbitration in HKIAC. The court of first instance in this case took a contractual approach to deal with this situation. It felt that the wording of finally resolved by arbitration would mean that these arbitration clause will only be breached if the foreign proceedings would have the effect of finally resolving the disputes between the party with res judicata effect. And because the Cayman Island winding up proceedings does not carry with it with this effect, therefore, by presenting a winding up petition in Cayman Island, it would not breach the arbitration clause, and therefore the anti-suit injunction was not warranted. So the application was refused by the Hong Kong court. But this case is currently pending appeal, so the outcome we are yet not known whether or not how it would come. And interestingly, in the company's application for interim anti-suit injunction pending appeal application, the Court of Appeal did comment that it is reasonably arguable that the CFI's construction on finally resolved is too narrow. So the outcome is yet to be seen, and very interesting to know what that would be. Now we have pretty much covered the recent developments of Hong Kong case or in respect of the petition that's subject to arbitration clause. We now turn to a comparative lens to see how other jurisdictions deal with that briefly. In the English approach, as laid down in the CM Participation Corporation case, it is a Privy Council's decision. It expressly repudiated the self-estate approach. So the test remains the traditional approach, which is bona fide dispute on substantial ground test. Hong Kong did not follow the CM case. And then in respect of Singapore, the relevant case is the NN Group and was subsequently followed in its Court of Appeal in the Singapore Commodity Group Company PT Limited case. It took a prima facie dispute threshold in considering this matter, which is that where there is a prima facie dispute over the debt falling within the scope of arbitration agreement, the creditor will lack the standing to wind up the company. And interestingly, even under the context of considering whether or not the petitioner is in abuse of process, the court will not engage in a merit assessment of the party at dispute as well. So that's a little bit different from the Hong Kong approach. In quick summary, when a petition that is subject to an arbitration agreement, the Hong Kong approach has been shifted from the traditional bona fide dispute on substantial ground to the multifactorial approach as laid down in Regaco Honglam case and the cases afterwards, which is that absent countervailing factors such as the insolvency risking a third party and the defense borders on frivolous or abuse of process, the court should stay or dismiss the petition to hold the parties to their agreement. So that's pretty much I would like to share with you today, and thank you very much for your attention. If there is any question, I'm more than welcome to assist.
Okay, so I hope you all enjoyed the break. And I hope it's energized you for the next series of presentations we'll be giving today. I am Angelica, and I'll be representing Singapore. Now, Singapore is a jurisdiction that whose reputation precedes it. And I have to admit, with my international background, I'm mostly Singaporean by nationality. But I'm here today, and I'll do my best to take you through Asia's leading arbitral seat, one of Asia's leading arbitral seats through the lens of anti-suit injunctions. According to the most recent Whiten Case and Queen Mary International Arbitration Survey, Singapore currently ranks as the second most preferred seat, tying with Hong Kong. And number one, we have London with 34% of votes from respondents, followed by Beijing in third place with 20%, followed by Paris in fourth place with 19%. Since 2015, Singapore has been steadily rising among the ranks, reaching fourth place that year, climbing to third place in 2021, and even tying with London for first place in, climbing to third place in 2018 and tying with London for first place in 2021. It's interesting that seats coming from a common law jurisdiction have been topping the ranks, and we know the influence of English law has a far reach. This is something that you'll see later on in the presentation as well. But indeed, this is also what Honorable Chief Justice Sundaresh Menon has stated. He says that the Singapore legal system continues to have an umbilical relationship with English law. But he does acknowledge that there are encouraging signs that our own case law is forming a critical mass. With that being said, what makes Singapore so special as an arbitral seat? Well, it is a neutral forum. It has the ease of enforcement as a signatory to the New York Convention. It prioritizes confidentiality in arbitration, and there's perceived trust in the judicial system. But also, Singapore has a policy of minimal curial intervention. This policy contributes to Singapore's reputation as a pro-arbitration seat. I quote, "An unequivocal judicial policy of facilitating and promoting arbitration has firmly taken roots in Singapore. The Singaporean courts recognize that alternative forms of dispute resolution prove beneficial to the parties as it allows them to resolve their disputes at a pace that they are comfortable with." We all know that an arbitration agreement excludes the jurisdiction of the courts, and yet court supervision is sometimes needed to support arbitration. So, one of the major questions that jurisdictions grapple with is what role do national courts have in arbitration? And where do we draw the line? Anti-suit injunctions encapsulate this problem. As Dr. Baltag mentioned earlier today, we have seen a shift in the perception of anti-suit injunctions. But firstly, what is an anti-suit injunction? Well, it is an order preventing a party from pursuing court proceedings in contravention of an agreement to arbitrate. Otherwise, it is crucial to point out that the order is directed towards the party and not towards the foreign court. Otherwise, if one court were essentially able to bar a foreign court's jurisdiction, issues of comity could come into question. However, there are objections to anti-suit injunctions. According to Axel H. Baum, they represent one more door opening for court interference in what is supposed to be a non-court private procedure. It is the thin end of a new and dangerous wedge. Given the tension, what I'll be examining in this presentation is how Singaporean courts deal with this. Specifically, how does it view anti-suit injunctions in the context of its limited powers to assist arbitration proceedings, as we see that there's a friction between the purpose of an anti-suit injunction, which is to enforce an arbitration agreement, and its nature, which is an incursion on the autonomy of arbitration. Despite this, there's been a recent wave of cases wherein Singaporean courts granted anti-suit injunctions. We have Asiana Airlines, Pertamina International, and Costco Shipping, all in 2024. So let's start with the question, do Singaporean courts have the power to grant anti-suit injunctions? If we take a look at the arbitration law, Singapore has the International Arbitration Act. And since it was enacted in 1994, it has incorporated the UN model law. Unfortunately, neither instrument explicitly deals with anti-suit injunctions. However, we can pinpoint two relevant provisions in the UN model law that may suggest that Singaporean courts may not have the power to grant anti-suit injunctions, or rather that this power would be contrary to the design of the model law. The first of these is Article 5 of the UN model law. It specifies that in matters governed by this law, no court shall intervene except where so provided in this law. Back in 2004, the Singaporean High Court took an incredibly narrow interpretation of this provision. It basically said, okay, the model law stipulates courts can't intervene except where so provided. And since the model law does not specifically provide a power to grant anti-suit injunctions, it cannot. End of story. This was later confirmed in 2013 in LW Infrastructure. But the High Court further clarified that the rationale behind Article 5 is not to promote hostility towards judicial intervention, but to satisfy the need for certainty as to when court action is permissible. This echoes the Court of Appeal's reasoning in 2008 in NCC International. So the main reason for prohibiting anti-suit injunctions is to create certainty for both arbitral parties as to the instances in which curial supervision or assistance is to be expected. The court consistently reinforced the idea that they only have a supportive and limited supervisory functions over arbitrations in Singapore. Furthermore, in this particular case, the Court of Appeal also examined Section 12 of the International Arbitration Act. In paragraph 1, it grants tribunals the powers to grant interim injunctions. In paragraph 7, it grants the High Court with the same power to make any orders needed for the purpose of and in relation to an arbitration. In this particular case, it upheld the same limiting narrative. By looking at the drafting history of the International Arbitration Act, it reiterated that the role of the courts was a purely supportive function, to lend assistance and not to liberally intervene, and to preserve commercial certainty. It further noted that the subcommittee that drafted the International Arbitration Act recommended that injunctive relief should only be granted where a stay is not appropriate and where granting this injunctive relief would not be considered an abuse of judicial process. The second provision that may pose a challenge to the grant of anti-suit injunctions is Article 16 of the UN Model Law, which, as we know, enshrines the principle of competence. If we consider that anti-suit injunctions are typically sought before the constitution of the tribunal or before the tribunal has determined its jurisdiction, the outcome is that effectively it allows the court to determine the tribunal's jurisdiction before it itself has the opportunity to do so. This concern was also pointed out in a case before the UK Supreme Court, where it stated before the court could order final injunctive relief, it had to conclude that there's a binding and applicable arbitration agreement. So given these objections, how do Singaporean courts justify their current power to grant anti-suit injunctions? Well, we start with John Reginald and others and Train US and others in 2009. In this case, the Court of Appeal drew upon Lord Gough's principles on anti-suit injunctions established in a case decided by the Privy Council in Brunei, which is now known to be the leading case on anti-suit injunctions in common law. So borrowing these principles, the Court of Appeal said that anti-suit injunctions could only be granted when the ends of justice require it. It should only be granted against the party, not the foreign courts. And the party to be restrained must be amenable to the jurisdiction of Singaporean courts, and the court's powers must be exercised with caution. But in addition to these four principles, the Court of Appeal added a fifth principle, namely that there must be a valid arbitration agreement and a breach thereof. Its justification was that it viewed it as it would only be enforcing a contractual promise. This was later confirmed in R1 International, which is considered one of the first cases that explicitly acknowledged the Singaporean courts' power to grant permanent anti-suit injunctions. The justification was that Singaporean courts could grant anti-suit injunctions due to its broad power to give injunctive relief for international arbitrations seated domestically pursuant to Section 4, Paragraph 10 of the Civil Law Act, and as a result, by extension, Section 12A, formerly Section 12.7 of the International Arbitration Act, allowed it to grant anti-suit injunctions in the context of foreign-seated international arbitrations. Keeping in line with Lord Gough's fourth principle, here the court establishes a high threshold for the grant of anti-suit injunctions and creates limitations to its powers. It says that policy considerations would come into play and that it should only grant anti-suit injunctions when strong reasons are present. Since then, the general principles on anti-suit injunctions have developed. In 2019, the Court of Appeal expanded upon these principles and created 5 considerations for when an anti-suit injunction can be granted. Namely, the court must consider whether Singapore is a natural forum for resolution of the dispute between the parties, whether the foreign proceedings would be vexatious or oppressive to the plaintiff if they are allowed to continue, whether the defendant is amenable to the jurisdiction of the Singaporean courts, whether the anti-suit injunction would cause any injustice to the defendant by depriving the defendant of legitimate juridical advantages sought in the foreign proceedings, and whether the institution of foreign proceedings was or would be in breach of any agreement between the parties. In this case, the court went further to assuage potential concerns over comity. It stated that the local court is not arrogating to itself jurisdiction over a dispute that a foreign court had exercised jurisdiction over. It is merely enforcing the parties' agreement. This is reinforcing its argument in John Reginald. However, it did acknowledge there are some instances where comity would be a concern, namely, in cases where there has been some delay in bringing an application for anti-suit injunctions. Here it stated that the longer the delay and the more advanced the foreign court proceedings become, the stronger the considerations of comity would be. The High Court expanded upon this in True Coin and Tectorix, stating that it would actually promote comity for the Singapore courts to deal with the anti-suit application before proceedings between the parties were further advanced, thus saving the time, efforts, and expense. Singapore's case law on anti-suit injunctions continues to evolve with issues arising from new angles. In 2024, the Court of Appeal confirmed in Asiana Airlines that generally anti-suit injunctions cannot be granted in relation to court proceedings being pursued against non-parties to an arbitration agreement. The court set out the conditions for granting anti-suit injunctions in this context by stating that firstly, you must prove that the agreement was intended to also cover the non-party. And secondly, you have to prove that the real purpose of pursuing the non-party was to bypass the arbitration agreement to make foreign proceedings vexatious or oppressive. Therefore, only in exceptional circumstances can an anti-suit injunction be granted to prevent court proceedings against non-parties. For the past 2 decades, we have seen Singaporean courts change their view on anti-suit injunctions. Back in 2004, there is a narrow interpretation in favor of certainty for the parties as to when the courts can intervene. However, we've seen over the past few years that the courts have shifted towards a mindset that anti-suit injunctions are for the purpose of enforcing of a contractual promise. But there are still limitations to preserve the divide between the courts and arbitration. Namely, to exercise this power with caution, that it is subject to policy considerations, and that an anti-suit injunction can only be granted when strong reasons are present. To conclude, Singapore has shaped its reputation as one of the leading seats in international arbitration by establishing a clear pro-arbitration stance with minimal curial intervention. However, with anti-suit injunctions, it has had to reconsider its stance, and we've seen this shift in its jurisprudence. To use Axel H. Baum's terminology, the anti-suit injunction serves as a weapon that can facilitate arbitration where a party is seeking to open court proceedings in contravention of an arbitration agreement. While there has been a recent wave of anti-suit injunctions being granted by Singaporean courts, the question remains whether this is compatible with the design of the UN model law. Is it justifiable? And what does this mean for other model law jurisdictions and their approach to anti-suit injunctions? Finally, the broader question is, how does this inform our philosophy with regards to the role of national courts in arbitration? Is it intervention, which holds a negative connotation reminiscent of meddling, or can we repackage it as involvement, which reflects a more hands-on approach that is still respectful of the jurisdiction of our arbitral tribunals? So I finish off this presentation with an invitation for you to ponder these questions. Thank you. And I would like to invite the next speaker, Dia, to represent India.
So hello, everyone. A very good evening to all of you present here, and a very warm welcome to all of you. My name is Dia Devle, and I am a part of the CIDR group of the LLM course here at Queen Mary. So it is a very big privilege for me to be standing here in front of all of you to present the jurisdiction that I come from, that is India. So the topic that I'll be presenting today is arbitration in India, a jurisdiction in transition. Now, if you wonder why the topic, a jurisdiction in transition, I hope my presentation today will exactly show you why. I would like to begin with a quote by Justice Nariman of the Supreme Court of India, who defines arbitration as a method intended to resolve disputes speedily, effectively, and with finality outside of the traditional court system. Now, this particular line, according to me, exactly tells us why we all are present here today. Because when we talk about arbitration, it is not just merely about resolving disputes, because litigation can do that as well. But what this line captures is trust, because arbitration is also more about preserving trust than merely resolving the disputes. Trust in neutrality, in efficiency, and in party autonomy. That is, when parties choose arbitration, their choice is respected and also preserved. Because when we talk about India today, we are not just merely talking about an institution or a legislation. We are morely talking about a legislation in transition, a transition shaped by legislation, by the growth of institutions, by judicial reforms, and by a steadily rising international confidence. And that is exactly what makes India's story worth telling. So it is impossible to take you through a jurisdiction without telling you what its founding features are and what its basis is. So we have the Arbitration and Conciliation Act of 1996, which today deals with all of the arbitration matters in India. And this is the Arbitration Act that we use in India. You can take a look at it later on if you like. So this Arbitration Act was a deliberate breakthrough from the old Arbitration Act of 1940, which had become a byword for excessive delays and court intervention. This act is specifically based on the ancestral model law, and which signaled India's intention to speak the same language as the rest of the arbitration world. The goals of this act were very straightforward and simple. First of all, to strengthen party autonomy, to reduce judicial intervention, to allow procedural flexibility, and to make awards genuinely enforceable. And these four founding principles still anchor India's arbitration today. So here, I would like to take a pause and put a question to all of you here. Well, India was not the only one who adopted its Arbitration Act from the ancestral model law. We have England and Singapore, which adopted from the ancestral model law as well. England adopted its Arbitration Act in 1996, while Singapore passed its International Arbitration Act in 1994. And when we talk about Singapore, it immediately gathered the attention and the trust of the most leading arbitration seat in the world, while England reinforced its position as a global benchmark. Then what happened to India? If all of the three jurisdictions took their arbitration laws from the same framework, why did the outcomes diverge so sharply? Well, where did India end, first of all? So it caught itself in a cycle of judicial overreach that the very system it adopted was designed to prevent it. Well, the answer, as I hope to show you all today, does not lie in the legislation. It rather lies in how the law was interpreted, applied, and then corrected. I'm going to give you all a quick overview of the Arbitration Act of India. So the Act is divided into two major frameworks. First is Part 1 and Part 2. Part 1 talks about the domestic arbitration and the international arbitration that are seated within India, while Part 2 talks about the enforcement and recognition of foreign awards. So Part 1 is essentially the process. It tells us how arbitration proceedings are conducted in India, while Part 2 tells us what the outcome of the arbitration is. So there are a few provisions under the Act which are very important, even in domestic arbitration and in foreign arbitrations. First, we have Section 7, which talks about what a valid arbitration agreement is. Now, in arbitration, nothing can begin without consent. So Section 7 tells us what a valid arbitration agreement is, and that agreement is the source for the tribunal's entire authority. No consent, no arbitration. The courts also play a supporting role over here. We have Section 9, which talks about the court's power to grant interim measures, such as injunction or preservation of assets. This tells us that the courts also assist in arbitration without trying to control it too much. We then have Section 16, which recognizes the principle of competence. Now, this doctrine tells us that the arbitral tribunal has the authority to rule on its own jurisdiction without sending the parties straight to the courts and keeping the challenges within the tribunal. Next, we have Section 34, which talks about setting aside an arbitral award. Now, what this section tells us that it tells us that the Arbitration Act has a framework of limited grounds on which the award can be set aside. Next, we have Section 36, which talks about the enforcement of an award. This section allows an arbitral award to be enforceable as if it were a decree of the court, because in the end, an arbitration is only as good as the enforcement standing behind it. Next, we have public policy and judicial intervention. If there's any topic in Indian arbitration that has gained much more controversy than any other, it has to be public policy of India. So under Section 34, an award can be set aside on the grounds of public policy. On the face of it, this is very sensible. No jurisdiction will ever enforce an award that is in contravention with its own fundamental principles. However, as I said, legislation was never the issue. The interpretation of the legislation was. So in oil and natural gas case versus the saw pipes, the Supreme Court read public policy to include the idea of patent illegality. Now, this widened the door considerably. And for a time, the Supreme Court and the other courts in India were looking at awards, were reviewing the merits of an award in a way that looked uncomfortably like an appeal. And when arbitration starts to resemble a litigation, it quite loses the very essence of why the parties chose it in the first place. However, India then corrected its course. In 2015, the amendment of the Arbitration and Conciliation Act took place. Now, this amendment narrowed down the scope of public policy considerably and confined it to only domestic arbitrations. So, international arbitration seated within India and foreign awards were kept out of the purview of this particular act. The Supreme Court settled its post-amendment position in Sangam Engineering versus National Highway Authorities of India. So in this case, the court set 3 ground rules on which an award can be set aside on the grounds of public policy. The court would not go beyond these 3 golden rules. The first one was that if the award was induced or affected by fraud or corruption. Secondly, if the award was in contravention of the most fundamental policy of the Indian law. And thirdly, the award conflicts with the most basic notion of morality or justice. These were the ground rules. The court were not allowed to go beyond it. So this arc from expansion to restraint tells us how the jurisdiction has actually matured, learning from its own mistakes. To understand India's arbitration evolution, it would be a good thing to compare it alongside 2 jurisdictions, England and Singapore. Now, why England and Singapore to be specific? First of all 3 countries are common law countries. Secondly, they have developed their arbitration laws based on the same uncitrul model law. And thirdly, when we talk about Singapore and England, they're the benchmark when we talk about arbitration. So Singapore adopted minimal curial intervention as its guiding principle since 1996 and has held that line consistently. England adopted judicial intervention and judicial restraint and party autonomy as its founding principles of the 1996 Act and has never meaningfully deviated from that line. And then what happened to India? If it started from the same particular path, where did it end? Well, it started off from the same path, however, took a different turn, one marked by expanding judicial oversight, interventionist instincts, and years of uncertainty that cost it credibility as a seat. The difference here was not just legislative, it was rather judicial and institutional. And it took a sequence of landmark judgments for India to begin closing the gap. Legislation could never have done it alone. A statute can only set the rules, but it cannot quite change the instincts of the people who are applying it. The judiciary has to evolve as well. And with time, the court started to accept a single principle that arbitration works best when courts step in only when they're genuinely required in arbitration and stay out the rest of the time. We have a series of landmark judgment which has brought India where it stands today. I'll be taking you through all of them one by one, starting with the Bharat Aluminium versus the Kaiser Aluminium case. This was the turning point for India. This is commonly known as the Balco case. In this case, the court held that the seat of arbitration determines which court will have supervisory jurisdiction, and that part 1 of the act applies to domestic arbitrations only. It will no longer apply to international arbitrations or to foreign awards. In doing so, it overruled its earlier decision in Bhatia International versus Bulk Trading Corporation. So this case had allowed Indian courts to reach into foreign seated arbitrations. The Balco case brought Indian jurisdiction firmly back in line with the international practice. Next, we have Vidya Drolia versus Durga Trading Corporation. In this case, the court said that when a judge wants to review if a matter is eligible to go to arbitration, the review should only be prima facie. That is a light touch. The substantive question should be left for the tribunal to decide. That strengthened the tribunal autonomy and cut out an early interference. Next, we have the Vijay Karya versus the Prismin Kavi case, which reinforced the enforcement side of the picture. The court stressed that refusing to enforce a foreign award should only be a rare exception and not a reflex. The message to the world was that India intends to honor foreign awards. Lastly, we have the Bharat broadband case, which turned to the integrity of the process itself, reaffirming the importance of arbitrator independence and neutrality. An arbitration can only command fairness in the process if the people deciding it are genuinely neutral. That decision strengthened the legitimacy of the whole system. So, where does India stand as a seat today? Well, the honest answer would be to go towards institutional arbitration and away from ad hoc arbitration. The 2019 amendment of the Act created the Arbitration Council of India, which is set to promote institutional arbitration as a matter of policy. Because institutions bring consistency, support infrastructure, administrative predictability, and credibility. Let's talk through the statistics. The Mumbai Center for International Arbitration recorded a 91% jump in its caseloads in 2024, and its updated 2025 arbitration rules embed virtual hearings and electronic filing as a standard. High courts across Delhi, Mumbai, Calcutta, Hyderabad, and Allahabad have been designed as courts of arbitration matters, reducing delays at the supervisory stage. India is trying to position itself as a preferred seat for South Asian and regional disputes where parties want a neutral, enforceable, and culturally proximate forum. Alongside that, there's a genuine judicial restraint. Indian courts today are noticeably more arbitration friendly than they were 20 years ago, and that has done a great deal for India trying to position itself as a global benchmark where parties can actually come to arbitrate. Next, we have fairness and neutrality. So at the center of all of this sits fairness, and neutrality. Because, according to me, what parties can live with is an unfavorable outcome, but what they cannot live with is an unfair process. When we talk about fairness and neutrality, they are not just the elements of arbitration, rather, they are the main essence itself. Both must hold. If either of them fails, the award fails along with it. Next, we have technology. India today is entering into a new technological phase. Artificial intelligence is increasingly being used for document review, legal research, data analysis, and case management, and the efficiency gains are real. India is not watching from the sidelines anymore. In the late 2025, the Supreme Court Center for Research and Planning published a white paper on AI and judiciary, positioning AI explicitly as an assistive tool for legal research, transcription, translation, and case categorization, while making sure that human judgment must be kept in the loop and must be used for the purpose of checks and balances. The court has also piloted AI Saransh, an AI-powered tool for that generates concise summaries of pleadings and helps identify the key issues at the outset of the case. We also have the Draft Arbitration and Conciliation Amendment Bill of 2024 that signals that India's next legislative wave would be a digital one. Singapore and England are moving in the same direction. AI assisted tools and virtual hearings have become standard features of leading seats. India here holds a structural advantage it simply did not have 20 years ago. As one of the world's foremost technology economies, it has the infrastructure to actually lead the particular shift and not just merely follow it. But the efficiency gains comes with real questions too. Can technology actually speed up things without eroding the due process? Can an algorithm grasp nuance, context, and procedural fairness the way a human arbitrator can? Well, to answer that, arbitration can and should embrace innovation. What it cannot do is hand over the human judgment at its core. Technology belongs in the room as a tool and not on the tribunal as a decision maker. Justice cannot be automated, but it can surely be assisted. Looking forward, India's ambition is no longer subtle, and for the first time, the numbers are actually starting to reflect it. The International Arbitration Center of 2019 is a clear statement of institutional intent. Fast track proceedings under Section 29B, introduced by the 2015 Amendment Act, allows awards to be rendered within a period of 6 months, directly addressing the delay that historically led parties to go to the major arbitration seats, such as Singapore and England. The Draft Arbitration and Conciliation Amendment Bill of 2024 proposes further reforms, including provisions for emergency arbitrators and stronger confidentiality proceedings, two areas where India has historically lagged behind England and Singapore. The gap with Singapore of 699 new SEAC filings in 2023 and with London as the benchmark for arbitration is still real, but the gap is surely narrowing. And the direction of travel across legislation, institution, judiciary, and technology is unmistakably forward. So let me end where I began from. I asked at the starting that why three jurisdictions, England, India, and Singapore, which adopted its arbitration laws from the same ancestral model law, ended up in such different places. Well, the answer, according to me, is not legislative. It is rather that they lacked judicial culture and institution confidence to honor it. India always had the right legislation since 1996. What it lacked was the judicial culture and institutional confidence. Arbitration depends on trust in the process, in the tribunal, and in the enforceability of the outcome. India's arbitration journey has not been smooth. There were a lot of detours, like the long argument over public policy or the corrections that took years to work through. But it is precisely by confronting these problems that the jurisdiction has matured. India today is not a perfect jurisdiction. No jurisdiction is, but it is a confident and increasingly mature jurisdiction. In my view, India today is no longer a jurisdiction that requires an apology or an explanation. It is rather a jurisdiction that requires attention. And if the current direction of travel tells us anything, it is that India's arbitration story is still being written and its most important chapters may still lie ahead. I hope my presentation now answers why the title, A Jurisdiction in Transition. I hope you enjoyed it and thank you for bearing with me. Thank you so much. I would now like to invite Toon to present his presentation on Thailand. Thank you very much.
Hi, good afternoon, everyone again. And thank you, my colleague, for presenting about the potential development in India. So my name is Chayan Chayaporn. I'm a qualified lawyer from Thailand. And to be honest, I'm not an arbitration lawyer. I'm a corporate lawyer for 5 years. I used to work in the public sector for 2 to 3 years. So I might not be the expert in this field, but I have reached out to several leading lawyers in my country for some guidance and information. And I'd like to thank them here from Kun Jet Sarit from Herbert Smith, Thailand, and Kun Ratchapon and Kun Kunatha from Watson, Bali, Thailand, and also Professor Amnat from Thammasat University, one of the best law universities in Thailand. So I'd like to thank them all here for providing me with some papers and research essays that I could rely on to present you here today. So my content will be an overview of Thailand, and then the key differences between model law and Thai Arbitration Act, and then refusal of enforcement, and then the last topic will be on government as an uneasy party. So the first question is, why do you need to know about Thailand? Like, in what occasion you will come into contact with this jurisdiction, and why should you know about it? So let's give you some snapshot about Thailand. So we are the third largest economy in ASEAN, or Association of Southeast Asian Nations. The 10th largest economy in Asia, 27th globally. We also have quite a number of foreign direct investment, or FDI, from countries. Top 10 countries are like Singapore, UK, Japan, China, Hong Kong, Taiwan, Indonesia, USA, Netherlands, Spain. So if your client is one of these, one of the companies from these countries, there's a reason that you may come into contact with Thailand as a jurisdiction. And also we have 35 BITs or bilateral investment treaties and 16 free trade agreements in force. Let's focus more on the arbitration framework. So Thailand is a contracting state to New York Convention, of course, and we also a civil law and a model law country. We have an Arbitration Act 2002, which is our lex arbitri, or our arbitration law. We are not an exit member. We signed the convention. We haven't ratified it yet. So if you want to sue our government, we need to use UNCITRAL rules. And we have had 2 cases so far in the history of Thailand. We have 2 major institutions, Thai Arbitration Institute and Thailand Arbitration Center. So if you want to choose Thailand as a seat, it's probably either one of these 2 institutions. They have very similar names, and sometimes some lawyers draft really bad arbitration clause, and it confuses between the 2. So make sure that you can differentiate and distinguish the 2 from each other. Also, under Thai law, foreign lawyers can represent parties in arbitration. So you don't need a qualified lawyer in Thailand if it's an arbitration case. And also, there is no distinction between international and domestic arbitration in Thailand. So for some statistics, you see that this is the most recent statistics from Thai Arbitration Institute. Not many cases, to be honest. In 2022, we had only 91 new cases. When you look at leading institutions like LCAA or ICC, that we have at least 900 or 1,000 or more. Or even sports arbitration in Switzerland, they have 900 cases each year. So 91 is quite a small number, but we are keep growing. We are keep working on it. and it takes approximately 1 year, 12 days per case. But if there's a challenge to the enforcement or challenge to set aside, it can go up to 3 years, 2 to 3 years. I didn't mention about the other institution because they have only like 16 cases a year, which is a very small number. Now, the second topic that we're going to cover is that the key differences between model law and arbitration act. So, I mean, there are many countries that adopt model law, and it's very easy to generalize them that they are model law countries. But if you look at the details, there might be certain unique characteristics. For example, under Thai Arbitration Act 2002, first, form of arbitration agreement. For us, it's quite a rather conservative side. The agreement must be in writing and signed by the parties. And also, interestingly, our law explicitly states that arbitration agreements between a government agency and a private enterprise are binding. This is to confirm that any private company that enters into an arbitration agreement with the government, that at least they can be comfortable and they can be assured that the arbitration agreement is binding. And the number of arbitrators under the model law, the default number of arbitrators will be 3, but for us is 1. And also for the interim measures and prelim orders, under our arbitration law, the tribunal doesn't have the power to grant interim measures and prelim orders, which means that you need the court's assistance and court's support if you want the other party to produce documents or take out certain other actions. Next, the rules applicable to the substantive dispute. To remind you, the model law is silent on this issue, but our law is quite specific. So if the parties fail to designate the law, the dispute shall be decided in accordance with Thai laws, save whether it's a conflict of law. The tribunal shall apply the law determined by the principal conflict of law it considers appropriate. And then the enforcement, again, quite conservative. We need certified Thai translation of the award and the arbitration agreement. They are mandatory. And also the enforcement application must be filed within 3 years from the day that the award is enforceable, which is quite limited. This now the last topic is, this is a little bit controversial. I've discussed with some lawyers because the immunity of the arbitrators under Thai law is that under Thai law, even though arbitrators are generally exempt from civil liability, but if they perform willfully and grossly negligently causing damage to either party, they can still be liable. And if they demand or accept bribes, they can be subject to criminal penalty as well, a prison for up to 10 years. Some lawyers I know express concerns about this greatly. Now for the refusal of enforcement, I show you here the unscripted model law on the left, and then the Thai Arbitration Law, Arbitration Act on the right. You can see that even though the grounds are very similar, so the first one is the arbitrability, and the second one is the public policy, right? But the literal translation of the term public policy in Thailand is public order or good morals of the people. In Thai, it's like ขัดต่อความสงบเรียบร้อยและศีลธรรมอันดีของประชาชน which is might not be the same as the definition of public policy under Amsterdam Model Law or even New York Convention. And we'll see some examples of how it is being interpreted under Thai law and jurisprudence, which is very interesting because I assume that many other countries with model laws, the literal translation might not be the same, but we approach them with a certain assumption that it's just public policy. It's probably the same, but actually might be no. So for the first one, the general one, arbitrability first, this is quite generic. So under Thai law, as a general principle, criminal cases, family law, inheritance disputes, they cannot be resolved by arbitration. And commercial disputes are generally arbitrable. Even registered trademark dispute can be arbitrable under Thai law. So in this case, the court decided because the decision directs a party to transfer a registered trademark. So yeah, it can be arbitrable. And also for consumer cases along the line with like the other leading jurisdictions, pre-dispute arbitration agreement in consumer cases is considered an unfair contract terms and cannot be enforced. And also for labor dispute, one of the most discussed issue, under Thai law is quite progressive because if any part of the dispute concerns labor dispute, the parties may litigate that part of dispute before the national court. And the remaining part, for example, like maybe commission fee or other arrangements, they can still be arbitrable under the Thai law. Now, the definition of public order and good morals of the people that I mentioned. What does it mean, and how do we know what the court will interpret? So I have a very recent court decision. Thank you to Kun Ratchapon from Watson Valley, who recommended me to look into this case. Let me try to be as concise as possible. So the first part, it says that the full decision of judges of the Supreme Administrative Court has ruled that the court has the power to examine the reasoning used by the arbitral tribunal in making it award, both on questions of statutory interpretation and on questions of the correctness of the application of the law to the facts, but they didn't lay down legal principles or define general legal criteria to apply in determining the scope and meaning of the public order or good morals of the people. It must be considered on a case-by-case basis. So they are saying here that yes, the court can review the reasoning of the tribunal, but we don't have a specific criteria yet. And then they even reaffirmed a very broad arbitration statement that, however, the scope and meaning of public order and good morals of the people must not be used as a tool by the party who suffer a disadvantage at the arbitration stage in order to have the court reopen proceedings on the issue in which that party was disadvantaged. It's a bit conflicting, right? Because the previous slide said that, yes, the courts have the power to review the reasoning. And here they said that, no, it's not a tool for the party to reopen the case. Okay, never mind. Let's look further. And then they say that, okay, now they set a new criteria, which can be quite useful. They say that the court must consider whether the award is based on facts and law that affect the fundamental structure of the legal system, or whether it is manifestly evident award that conflicts with common sense of justice, thereby constituting a violation of public order or good morals of the people. For example, an award ordering the delivery of narcotics or drugs, or award ordering payment pursuant to a contract made through fraud. So here, they set certain criteria, and we can assume, we can derive from this case law that this decision confirms that the court can review the reasoning. However, there's no specific criteria, and this court decision tried to come up with a criteria that you must check if the award is based on facts that affect the fundamental structure of the legal system, or manifestly evident that it conflicts with common sense of justice. It doesn't help much, right? To be honest, it's still very vague and very broad. Anything can fit into these two criteria. Now let's see some examples so far. So these are a few cases that you might consider interesting. So the awarded interest rate beyond specified in the main agreement, consider a violation of public order and good morals. And presiding arbitrator's lack of impartiality, also consider a violation of public order and good morals. And this is very interesting, compound interest, because in this case, the contract was governed by English law, which they allowed this, right? But and then to try to enforce a foreign award in Thailand. But Thailand says that the compound interest is against the mandatory provision under Thai law, because our Thai law really bars compound interest except for certain circumstances. So they didn't enforce the award. Very interesting, and it's considered fit into public order and good morals of the people too. How? I don't understand as well. Now the last part, the issue even becomes more complicated when government becomes a party in a contract with the private company. So you see that as a small country like Thailand, it might be very likely that if you come into contact with Thailand, it will be because you have our government as your client. And then, government is not an easy party. For some examples that I will show you. The first one is that this case is straightforward, but also problematic because so you're a private company and you try to enter into a contract with the Thai government, a Thai government lottery office, and then there was a dispute and the award was rendered in favor of the private company. Then Thai court refused to enforce the award because they said that the government lottery office didn't follow a procedure when they enter into contract with you. So we're just going to set aside the award. Just because the government body didn't follow their own internal procedure, they didn't obtain certain approval before they enter into a contract, and now the private parties who contracted in good faith bear the entire risk of the state's own internal procedural failures. Is that the public order and good morals of the people? The second is the ITV case. So this case is quite similar. So for example, in Thailand, when you are a government body and you want to enter into a contract, a big contract with a private company, you need the cabinet's approval. So you need the PM to say, yes, okay, let's enter into this contract, right? And then, okay, the cabinet approved a principle to enter into an agreement with a private company in this case. And then they negotiated an additional clause in the contract. This clause is saying that if the government or other government bodies offer the same package as under in this agreement to other private companies, you will compensate us, you will negotiate with us and find a mutual beneficial resolution or something like that, blah, blah, blah. And that happened, and the dispute happened. The tribunal rendered an award in favor of the private company again, and then they went to the court, and Thai court said that that contractual clause was after the cabinet's approval. You didn't have the authority to accept this negotiated clause, so we're going to just set aside your award. Which means that how can private parties rely on negotiated contract terms with state agencies if the terms can later be invalidated for non-compliance with their own internal procedures? And the last case is one of the biggest saga under Thai arbitration law, or even Thai law in general, the Hopewell saga. So a government body tried to, they contracted a private contractor, in this case it's an international company, to build an elevated pathway. I show you the legacy until today. It's still like that until today in that stage. So very interesting. There was an award rendered in favor of the private company again, of course. But in 2014, it was set aside because the claim was treated as time barred. They didn't file within 5 years limitation period under Thai law. So it was time barred, it was set aside. And then 2019, the Supreme Court reinstated. They said, no, we cannot apply the law like that because the law that states about time bar was enacted after the case. So they said, no, we're going to reinstate the award for you, which is in favor of the private company, of course. But in 2021, the Constitutional Court said that, oh, no, in 2019, that was contrary to the constitutional law because of being time bar. So we don't know yet how this is going to end, but let's say that it caused confusion, big confusion to private companies, because how many times can an award be reviewed and changed back to front to back like this under Thai law? So in conclusion, there's a Tinglish in Thailand that commonly used phrase. Tourists might be familiar with it. It's same, but different. It is used a lot in Thailand. So thanks to Urban Dictionary, it says that It's used a lot in Thailand, especially in attempts to sell something that can mean just about anything, depending on what the user is trying to achieve. For example, is this a real Rolex? Yes, sir. Same, but different. So, international arbitration in Thailand. Maybe we can use the same saying. We use the same model law, but different content. We use same grounds for refusal of enforcement, but different details, interpretation, and jurisprudence. We use same legal framework, but different outcome when the counterparty is government or state-owned organization. So I made you sorry for the AI slop, but I made you some comic to show you that I hope you get it, right? Is this a real Rolex? Yes, sir. Same, but different. Is this a model law? Yes, sir. Same, but different. So yeah, I hope you learned something about Thailand today, and maybe if you come into contact with Thai jurisdiction, you might remember about something that I said today. So thank you very much, and please let me know if you have any questions. Thank you. So feel free to ask any questions you like, and
as I understood, those cases which were described in the presentation, they were related to international arbitration, but the seat of those arbitration, is my understanding correct that was Thailand? Why the decision was set aside?
oh, sorry, it was being refused to enforce.
It was being refused to enforce. Okay, no. So the seat was outside Thailand.
Yes.
Okay, I got it. And what about any attempts to enforce it outside Thailand?
Oh,
They were unsuccessful.
I don't know. Yeah, I'm really sorry. Yeah, I don't know because we think I think Thailand rarely being the seat. Like I told you, like there are like 90 cases per year, and most of them are probably domestic.
Same. Okay, and then I wonder, it's the same situation. Maybe there are some kind of more positive cases which were enforced now.
Yes, actually, they are. For example, like I told you, the registered trademark or some labor dispute, it's very progressive. But when the government body comes into play, for example, like under Thai law, I'm not sure if it's the same in your country, but under Thai law, there's a provision that allows the court to reduce the penalty, the fine. For example, if you default a contract, if you breach a contract, and then you say that the penalty £5,000 a day, the court can say no, not proportional. And then in one arbitration between the government body and the private company, the tribunal used this same provision to reduce the penalty, but he reduced too much, and the government got too little money from the private company. And so the court set aside that award, saying that they used too much discretion to reduce the penalty, that they will fine the private company. So you should do more. You should charge them more. You should decide more in favor of the state, and that's just contrary to public order and good morale of the people. So they set aside.
I would say, unfortunately, not only in Thailand.
All right.
Sometimes we can see that. Let's say some other jurisdictions.
Oh, what a relief! Yeah.
Yeah, and also I would say that we also have a kind of civil law provisions in which, for example, in our country, in Russia, the amount of penalties might be reduced, and by the way, significantly by the court. Fortunately, it's happening very, very often, but mostly in this particular case, it is the issue of the forum we decided. So in the theory, we treat them as a discretion of the forum. So I would say, broader sense, it wouldn't be quite reasonable if you try to challenge the arbitral award in this part, telling that the discretion of the forum was kind of abused, or let's say, I don't know, its implementation were out of public order. It's kind of a bit too much. But same concept here helps.
But different. Yeah, thank you. So I don't want to end in two negative notes. I'm going to say that yeah, I mean, if there's any competitive advantage of using Thailand as a seat, it's the price, it's the cost. It's much cheaper than our neighbor Singapore. So if you worry about the price, you can come and choose Thailand because we also international, you know. And you ask us like, are we the same as Singapore? We answer same, but different. Yeah, so thank you very much. Thank you. And thank you everyone for staying with us till now. Next, we're going to have a roundtable discussion on intervention of court. The last roundtable discussion will also be moderated by Joao. And with all the speakers as well as Sushi, right? Sushi from Malaysia.
So can we start this roundtable? Yes. Yes? Okay, let's go. So first of all, thank you very much for your amazing presentations. I think it was very useful and very insightful to hear a little bit of different jurisdictions in Asia. I promise that I'm gonna stick to the script and because it's easier. So maybe we go through the first topic that we want to approach with the objective is to have a little bit of a comparative insights between some topics. The first one would be the role of the national courts and the arbitration. The first is the public. It's the public policy and the role of public policy. Do you want to do the questions?
Sorry, what questions do you have for me?
So the first question would be the significance of public policy role in arbitration, especially because it's setting aside the refusing enforcement and recognition, and public policy has this role, this great role. So the first question would be: is the range of public policy in your jurisdiction considered like broad or more narrowed? And how do tribunals use it as in terms of do they use it to set aside and review the law and review the law that the tribunals apply in the awards, or if they are more pro arbitration in the sense that it's very narrowed, and yeah, so would you like us to please guide us through your jurisdictions so we can have a little bit of a discussion around it?
Yeah, okay.
Maybe
So,
we can start with Sophie. Would you like to start, or
sorry. Okay, I'm Thank you. Sorry, I am speaking on behalf of the Malaysian perspective. So we are a model law jurisdiction, and we very deliberately moved away from court intervention in 2005. So we are very pro arbitration. In 2019, in the case of John Daniel against Vincent Tan, we have decided that the court's powers only extend to compromises in the integrity of the arbitral process, such as fraud, corruption, or the breach of natural justice. We therefore do not do merits reviews. We also, in this regard, try to repeal the Section 42 of our Arbitration Act, which originally let courts answer questions of law on award, which would basically be an appeal in all but name. After the courts had widened it, previously we basically repealed in 2018, and therefore we don't actually have it. It means to appeal arbitral awards in our courts.
okay? So it's more. So it's more pro.
It's very pro arbitration.
Yeah, in mainland China, I think the general attitude for the court towards arbitration is we are very arbitration friendly. And as for I shared in my PPT, and Supreme Court has a lot of cases that have a definition of the public policy. For example, it is a breach of the fundamental principle of the law. The second one is the breach of the national sovereignty. The third one is the breach of the good moral, and the last one is the breach of the the last one is the last one is the breach of the security of the security. Yeah, the security. So this is the definition from the Supreme Court's idea, the opinion. But for the High Court, Supreme Court, and the intermediate courts, they are very carefully use of the public policy, the concept of public policy. Because in general, from the statistic that I show in my PowerPoints, that the rates of setting aside the foreign related award and the rates of denying the recognition of or enforcement of arbitration award is quite low. So in general, although for mainland China, we are arbitration friendly jurisdiction. So that's me.
For those who joined us recently, Singapore is a very pro-arbitration jurisdiction with minimal curial intervention. With regards to public policy, I believe it keeps in line with international standards, and I think particularly it has a high threshold for public policy. To my understanding, something that would be something that would shock the public conscience.
I think in terms of Hong Kong, it shares the same spirit with the Singaporean arbitration law, is that it is very sparing use of public policy as a ground to set aside an award or to refuse the enforcement of the award, that it need to shock the conscience of the court that the enforcement or the award would be allowed. And although there's no specific definition of what is public policy in arbitration ordinance, as developed in case law, it means like the fundamental, contrary to the fundamental conceptions of morality or justice of the forum. So maybe it's a bit like like general stuff as what it is like. But although there are like a sparing use grounds of public policy, but like as some kind of examples, maybe the arbitral award was procured by fraud or criminal conduct, or maybe there's a serious procedural irregularity such that the tribunal fails to address a very critical point of the parties, or even there is a serious irregularity in terms of the arbitrator's conduct. Like in one case, the arbitrator even not paying attention to the hearing, and then they even like at the end of the year not coming close to it, and then he traveled in his private car. So actually he's not paying attention, not listening to the parties. So yeah, and then justice needs not only be done, but needs to be seen to be done. So in that case, the award was not allowed to be enforced. So yep, I mean, as general introduction.
So to answer that question, historically speaking, the range of public policy in India was actually very broad. We have this 2003 case, ONGC versus Sawpipes, in which the court actually tried to review the merits of the arbitral award itself. And that was not at all the right thing to do, because when arbitration looks like a litigation, why would parties ever choose it? Exactly. India then, however, corrected its course in 2015. The amendment of the Arbitration Act took place and that set 3 ground rules for any award to pass the public policy banner. The 3 grounds were if the award was induced by fraud or corruption, secondly, if there was fundamental violation of the Indian law, and thirdly, if there was a serious breach of the principles of morality or justice. So these were the ceiling. If they were to fall under these grounds, only then the public policy banner can be used. So right now, the courts cannot go beyond these principles, and right now we are more arbitration friendly than we were. So yeah, that's it.
I think for Thailand it's still quite broad, public policy, because the term public policy is also in other laws, not just arbitration acts. And I discussed with some Thai lawyers that even judges or lawyers in Thailand are still confused between the term public policy in other laws and the public policy that New York Convention means. So when the line is the judges use the same jurisprudence about public policy in other laws to apply to award of arbitration, which is not correct, and the recent decision trying to remind the other judges that the one that I showed you tries to remind the other judges, no, like, it's not the same. Public policy under arbitration law is not the same as public policy in any other laws in the country. You should distinguish the two. So yeah, it's still quite problematic.
Thank you. Yeah, so public policy usually is very well in pro-arbitration jurisdictions. They try to restrain that as much as possible. So, but yeah, some jurisdiction like that is still maybe courts are tempted to use it as this valve to review some awards. But taking a little bit of this I feel from the discussion we're having that Asia seems to be more pro-arbitration. And in regard to this concept of being pro-arbitration, I also want to hear a little bit of how is the courts assist tribunals. So I think there's also in terms of, for example, interim measures. Do you know, although interim measures made by tribunals, the enforcement of those interim measures may be a little bit more challenging, even in more pro-arbitration scenes. For example, I think here in the UK is also there's also this problem of enforcing those interim measures. But so my perspective is it's easier to go to the courts and actually ask the interim, the preliminary, an injunction, for example, in the courts, rather than ask the tribunals then to enforce in the local courts. But I want to hear your impressions on how is your jurisdiction is, how do courts actually assist tribunals in terms of interim measures or set aside of the awards or review of arbitration clauses, for example. It's also something that I want to like to hear from you.
Yeah, because my understanding is that we basically try to not do anything. Basically, we only try to support and not supervise whatever's going on in the arbitral courts. So we try to help appoint arbitrators and enforce interim relief and enforcement. And while we do have the ability to set aside awards under Section 37 of our Arbitration Act, it's very narrow. And case of Nelson now did confirm that the arbitral court holds exclusive supervisory jurisdiction. Outside of that, I am not entirely sure on how we would try to enforce any interim measures if one did arise, and I feel like I need to check. Right? Like,
Don't worry. Thank you.
In mainland China, as for the interim method, according to our new arbitration law, the power for granting the interim method still belongs to the courts. But it doesn't mean that we are not the pro-arbitration jurisdiction, because the reason why we decide that only the courts has the power to issue the interim method is that it is based on our history and also our real situation of the legal system in China, because we treated the power of issuing the interim method to be a judicial power, and only the courts, which is a part of the judicial system from the judicial system that has the judicial power. But the tribunal, since it is the power of the tribunal is from the party's autonomy, so it is not a part of the judicial system. So that's the main reason why the power still belongs to the courts. Yeah. So, but in practice, although the power belongs to the courts, since most arbitral institutions have made into their arbitration rules that they have the power to make a decision of interim method, it means that in practice, if the courts receive the decision from the tribunal, that the courts will make it into enforceability immediately through the formal review instead of the substantive review to support the tribunal to issue that kind of decision. So
Thanks very much. I think just before we go to Singapore, in terms of the support of tribunals, I would like to hear maybe, especially regarding Hong Kong and the relationship with Hong Kong and China and Macau as well, because those are regional separate jurisdictions, but they are part of this. Their sovereignty belongs to China, and maybe it could be interesting to, I don't know, hear your insights about the relationship of how do Chinese parties go to Hong Kong and how free they can go to Hong Kong or to Macau, and how do tribunals in China accept or support those arbitrations that, despite being held be seated in a jurisdiction like Hong Kong, they are still connected with China and the Chinese. I think I heard something. There was some developments, and I'd love to hear your takes on those. Maybe.
Yeah. So thank you for your question about the Hong Kong's effort to leverage its close tie with mainland China in support of the development of international arbitration. I remember that's one arrangement that has been covered by Sophie as well, which is the arrangement of mutual interim measures assistance from the court or something like that. So by that time, it's like Hong Kong is the first jurisdiction that formed this kind of arrangement with mainland China, whereby the Hong Kong State of Arbitration can directly go to the mainland court for interim measures, for example, the preservation of evidence, preservation of conduct, preservation of assets. And actually it means a lot to arbitration seated in Hong Kong, because like due to the frequency of the transactions between the two areas, like cross-border transactions, actually there are a lot of arbitration cases, there's multi-party, including the parties in mainland China. So actually maybe the respondents have assets in mainland China. And if those assets are actually out of the reach of Hong Kong in the middle of the proceedings, then that might be a problem, because like maybe at the end of the hearing in arbitration, because they might take times, right? Maybe the respondent has already moved the assets to somewhere else, but because of the arrangement in place that provides like the more convenient way for Hong Kong State arbitration to directly apply to mainland court to apply for maybe preservation of assets order, so to assist the arbitration in Hong Kong. So I think that's most prominent example I can think of in terms of like the cooperation between mainland China and Hong Kong in terms of arbitration.
Yeah. Besides the arrangements for the interim method, we also have one arrangement regarding the mutual recognition and enforcement of the arbitral awards, and one supplementary arrangement of this issue between mainland China and Hong Kong, and also Macau SAR. Because the reason why we have this arrangement is because before 1997 and 1998, the legal basis of this region to enforce and recognize the arbitral award is based on New York Convention. But after 1997 and 1999, that the return of Hong Kong SAR and Macau SAR, that we found that we lack a legal basis to recognize and enforcement arbitral awards. So that's why the governments in Hong Kong and Macau and also mainland to make agreements and make an arrangements to have a solid legal basis for both region region to recognize and enforce the arbitral award.
Can I ask this question? How do you think, how long does it take to receive measure from the court?
How long?
You mean from the court, mainland court, that under the arrangement, or is it usually like a normal arbitration situation?
I mean, there is an arbitration, so one of the parties needs to receive the interim measure. It varies. So in some cases, you need to receive kind of decree from the forum, from arbitral forum. In some cases, you need to go directly to the court. That's how it's regulated in the country. So I wonder how long it might take, whether you receive a decree from the, say, from the tribunal. Maybe you try to receive it by yourself, or how likely they will assist you.
I'm not sure, but I think it depends on what you're signing with, because the tribunal will probably be very fast. But the problem is that some jurisdictions don't recognize or the enforcement of the interim measures given by the courts. Like Sophie was saying, right? If I got it correctly, China says that interim measures can only be given by the own courts in China, right?
And that's what I mean exactly that. If you go to the court to receive interim measure, first of all, how long does it take? And secondly, how likely the court will assist you? I mean, the state court will assist you in your arbitration by providing you with the interim relief.
As between Hong Kong and mainland, I don't know the exact time that it takes in practice. But if the interim method, if the arbitration happens all within mainland China, that according to the case that I show in my PowerPoints, that BAC, which is Beijing Arbitration Center, issue an interim method in 2025, and it is the first interim method cases that happens in China because it is issued by the tribunal. So from that cases, the Beijing court, I remember I forgot the exact date, but it will not take so long for the courts to grant the enforceability of that specific interim method decision, which is made by the tribunal. So I don't know the exact date, but it won't take so long. Yeah.
And for example, if the interim measures were, let's say, issued by the tribunal, does it mean that there is no way to go to the court? Because, for example, I can assume that state court can, let's say, either enforce it or either just make a relief on its own statement, just to make a decision whether you need it or not. Or if, for example, you have an interim measure granted by the tribunal, it means that there's no go. You can't go to the court and ask for, say, enforcement of this award or granting a second award issued by the court.
According to this China's arbitration law, because the power to grant the interim method belongs to the court. So when the tribunal issue the decision, it is not enforceable. You still need to go to the courts to make it enforceable. Yeah. So the decision that made by the tribunal is not enforceable. Yeah.
Okay.
Thank you. And maybe we could go back to Singapore as well if we wanted to see.
Well, I mean, while we were still fresh on Hong Kong, maybe you could still give answer the question
From
the original question.
yeah, about the granting of the interim measures. I think there's difference between like mainland China and Hong Kong in the respect that actually like both Hong Kong court and tribunal can grant interim measures. Yeah. Yeah, and then like as actually is under section 35 of the arbitration ordinance. It says that tribunal can may grant the interim measures upon the request of the parties unless otherwise agreed by parties. And then pursuant to like section 45 of the arbitration ordinance, the court also has the power to grant the interim measure in support of arbitration upon the application of the parties. But in terms of like when you inquiry, like if the tribunal can order the interim measure, whether or not the court will order it when the tribunal has this kind of power. I think in terms of like Hong Kong's position, although I personally have no experience in dealing with that, but in terms of my knowledge, it is no bar that once the tribunal has the power to order interim measures, the court will not order an interim measure, but that would go to the consideration of the court. If you are going to the court, and then the court may consider, oh, maybe this matter should be better dealt with by the tribunal. That might be one of the consideration the court would take when dealing with the interim measures application. Yeah, interesting.
And how in Singapore? It's Singapore. Do they have do courts allow the enforcement of interim measures? How do they support the arbitration itself?
Well, I know I say that Singapore has a policy of minimal curial intervention, but
Yes.
that doesn't necessarily mean that it doesn't have a positive relationship with courts, I think.
Yeah.
I think historically speaking, Singaporean courts have been more hesitant to intervene, but it's changed its attitude. I think if we look at Section 12 of the International Arbitration Act, it gives tribunals the power to grant interim relief.
Yeah.
And then in the same provision, it also gives the courts themselves the same rights as the tribunals, but with the caveats that it's for the purpose and in relation to arbitration. So the limitation is just, to support arbitration proceedings. And I don't want to sound like a broken record and refer back to my presentation, but
Yeah.
with regards to anti-suit injunctions, it also still keeps limitations. Like there has to be strong considerations or strong reasons, and we have to keep in mind the policy considerations.
Thank you. And moving back to India.
Yes, so under Section 9 of the Arbitration Act of India, we have the provision for courts to grant interim measures where they can actually grant measures such as injunction or preservation of assets. Now, this actually is very helpful in case of urgent cases where urgent situations where the tribunal is still waiting to be formed and the purpose should not be defeated, and therefore the courts do help. The tribunals also have the power to grant interim measures under Section 17. However, the powers are not as vast as the ones that are given to the courts because the scope is a bit relatively less. But we have the 2015 amendment, because of which now the tribunals are also allowed to give interim measures. But of course, on paper it looks very good, but in reality, there's a lot of deviation that has taken place. But to talk about the role of courts, they actually are pro-arbitration and they act as gap fillers because they step in when the tribunal is not yet formed, but they step out when the tribunal is in their place.
And final but not least, Collins.
Yeah, in Thailand, we can enforce interim measures by tribunal. And also,
Correct.
I mean, the law doesn't say that they're enforceable.
Yeah,
You're silent on that.
it's silent.
Yeah, it's not the same as a law.
Yes.
And also we don't recognize partial awards.
Right.
Or interim awards. So which means that you need to come to court. And I don't have any hands-on experience, but based on the publication and my research, that courts always respect parties' agreement to arbitrate. So they usually transfer a part to tribunals only. But for multi-tier clauses, might not be enforceable under our law, like 30 days, 60 days, 90 days, or multi-tier dispute resolution. Based on my research, yeah, courts, but not quite. They ignore it.
They ignore the multi-tier.
And another thing that I noticed is that we have lots of courts.
Yes.
For example, like based on the merits of the cases, like we have civil courts, then we have administrative courts for example, the contracts between the government and private party, like concession contracts. You go to administrative court, and they have their own jurisprudence, and then you go to intellectual property court, intellectual property and trade court. They probably have different levels of judges, different levels of review quality, and it's quite difficult to assume certain standard.
Yes.
Different ones.
Thank you very much for your takes and your insights. I think we are running out of time. So I want to ask you a little bit of a question that I think it's, in your opinion, what would you think that it could be an introduction or something that you think in your own law, in your jurisdiction, or the jurisdiction you're representing, that could make arbitration more attractive and your local jurisdiction as more attractive to become the seat of arbitration in international arbitration. So it's a non really prepared question, but I think it could be a interesting something interesting to discuss. Does anyone want to start?
No, because yeah, never mind. Yeah, because for Malaysia, I think it's quite. The main thing for me would be that we are quite famous for Islamic finance, and we are an Islamic finance hub. And our central bank act has made reference to the Sharia Advisory Council, which is mandatory, and it is actually binding on the arbitrator wherever Sharia law arises. And that would be quite attractive to people that are looking to arbitrate on matters that incorporate Islamic finance, which would set us apart from most of the various other major jurisdictions here, except maybe Indonesia, I would think.
Yes.
So that would make us more attractive.
Thank you.
Okay. As for mainland China, I think the biggest attractive one is we have a big market. I do think that a lot of clients are from mainland China. Yeah, so we have a lot of manufacturer factories, and sometimes it will cause a lot of cases. Yeah, so I think this is the biggest attractive part. The second one is that with our revision of the new arbitration law, it turns out that we are more and more aligned with the international arbitration standards, but at the same time, we do keep our own China's characteristics based on our based on our reality. So we are not aimlessly adhere the global standards, but also have on our own characteristic. And the third one is we have a lot of famous cities, for example, Shanghai, Beijing, and also Shenzhen, which according to the primary surveys, these seats are quite popular around the world. And the arbitration institutions such as CTAC, SCIA, and BIAC are all our leading arbitration institutions here in China. And we do have make good use of AI, and we have very good equipment for the party, for the arbitrator to hold the hearing. So yeah, this is, I think, the charter part for mainland.
Well, I know Singapore is Singapore's the one to beat, right? So it's the benchmark, and every single presentation today, Singapore has been name dropped. But I don't think Singapore is doing anything too crazy in its arbitration law. I think, it's a model law country, and I think again it's just trying to be consistent and uphold like international standards. But I think sets it apart is really its reputation. I think geopolitically speaking, it's a good choice as a neutral forum. And yeah, I think Singapore has just gotten good PR. I do want to note that Hong Kong is also now like rising in the ranks. So maybe Esther could maybe talk about that.
Can I just say, I think Singapore also does one thing very interesting that attracts a lot of retired judges from the common law and put them in their courts, which is something that's, well,
Yes, actually,
repetition, right? A lot of people. We had a professor here with. He's now also based in Singapore, right? What's the name? Status. He's now in Singapore, if I'm not mistaken. But yeah, Singapore attracts also people with reputation, which is great. But Hong Kong is also very.
We used to have Blossoms and sitting in our quarterfinal review as well. Yeah, so I think that's something that we developed like in common as one of the most welcome seat of international arbitration. I think Hong Kong recently is doing very good in terms of like extending its international outreach. Like for example, although it's not completely related to arbitration, but there is new organization which called the International Organization for Mediations, established in 2025 last year in Hong Kong. It's actually the first treaty-based intergovernmental organization that's dedicated for mediation, for example, for state-to-state dispute resolution in terms of mediation, state and investor, and the disputes as between private parties for international commercial disputes. So I think these kind of organizations can boost at least Hong Kong as is one of the famous hub for international disputes resolutions. So yes, I think if to keep on the road and continuing to extend the international outreach, that could elevate Hong Kong as the famous hub for arbitration as well. Yeah.
Well, if you are a person for whom success comes after a lot of hard work, you would very well know how to preserve it. So India is one such jurisdiction. And today, India is at the forefront when we talk about technology. We are rising, we are going towards steadily institutional arbitration rather than ad hoc arbitration. And so if you're a seat who wants strong laws, who wants a lower cost as compared to England or Singapore, and if you are willing to be a part of a jurisdiction that is on the upward trajectory when it comes to arbitration, India is the right seat because we now have the judicial culture, which we did not have back then. And we also have the institutional confidence, which is building. Yeah, and we are gaining credibility with time.
Very good.
It's a very difficult question. What to introduce to save arbitration?
Something that you think, if Thailand introduced in a few years, for example, what do you think that could be something strengther in the law, for example, that could elevate the status of arbitration in Thailand?
Still a difficult question. I mean, I think we the human capital. I think our new judges very experienced, very understanding of international commercial trades, and that's something that we're proud of. I think judge education, and I think that's one of the most important parts that of a good seat.
Yes.
So maybe we need to learn from like what Dia mentioned about India. It's not about the law, the black letter law. It's about the jurisprudence, the culture of the courts and the judges and the people in power in Thailand. So I think I mean our new judges will understand like what's the principle of arbitration, and I believe they will respect them. So if there's anything that we should do is probably encourage these judges to take a stand and make bold decisions that protect the autonomy of parties in the situation.
Interesting. Well, thank you so much. I think we now have a little bit of maybe a Q&A. If anyone has to, Pavel, do you have anything to ask?
This topic
Yes.
is going to be broad, so there are always some questions. For example, I can say from perspective of Russia that we basically have a problem with the civil release, not only in arbitration but also in general litigation. It's not easy to receive interim measures, and moreover,
Why is that?
just like I'm explaining that.
Because it takes a lot of time, because of
No, this is the kind of approach which our courts tend to apply. So this is the kind of our courts tradition.
Max, do you that are a prominent practitioner in Russia? Do you want to give your
I'm
takes?
also a practitioner.
No.
This is kind of.
No, but Max, there's a lot of practitioners.
But you agree that there is a problem.
Yeah.
We have this problem, and I spoke to different judges and arbitrators while those events we have in London, and most judges and arbitrators in Europe said exactly opposite. That in Europe it's very highly likely that if prima facie there is a case, then you will receive interim measures. Opposite to Russia, unfortunately. So you need to deal with the case during you can receive the enforceable, let's say, resolution or an award, and still you might not have
The freezing injunction.
basically they are possible. Sometimes we can get them, but it's not a kind of general rule. It's kind of exceptional, rare issue.
If I may say, so interim measures are also exceptional, right? So it's because they're
Exceptional,
preventive
the
and
exceptional
defensive.
sounds a bit too much because it's not an exceptional one, but it's a bit rare than it should be.
Right.
Because
I-
and it depends on type of measure. For example, if you need to freeze the equity,
Exactly.
basically might be okay, but not in every case. But you still there is a chance. But if you need, for example, to freeze some amounts, the bank account,
They're very conservative. in that sense.
yes, very. So I wonder how it works in your jurisdictions. Is it highly likely that if you go to the court for interim measures, you'll get them?
Do you think they're conservative or they're more, they would be, for example, with less evidence about the urgency of the measures, for example? Would you think that they would grant the measure more easily, or like Rafael was saying, they're very conservative and only with maybe strong evidence or strong reasons behind it would they grant it in a very exceptional? Does anyone want to give a take?
I can make it easier. Is it possible to get them? Is it? How
I
likely?
heard that
Yeah, I think from the general perspective in terms of the court's attitude, Hong Kong court's attitude in granting the interim measures, although not in respect of arbitration proceeding, but even like in court proceedings. My observation is that it's not something exceptional that the court would grant interim measures, like for example, freezing orders, security for cost, or like summary judgment, this kind of like someone maybe out of that, but like freezing orders or security for cost, these kind of interim measures are quite common in Hong Kong courts litigation proceedings. And of course, they will have like a different consideration. Maybe, for example, for freezing order, we will consider of course the merits of the case, whether or not that would be a serious case which should be tried or good arguable case. And then maybe we would also consider whether or not there is a real risk of dissipation of the asset. But this not like speaking from my experience, it's not something very difficult to match. So I would say that it is not uncommon in Hong Kong court litigation in terms of granting interim measures.
I had a case in Hong Kong, and we were granted the freezing Mariva. Mariva injunction very quickly.
Yes.
Both locally and internationally,
Oh,
because they
worldwide
also
injunction.
did the worldwide Mariva injunction. And
Yeah.
it was extremely fast, and
Yes.
the
Yes.
banks accepted right away.
Yes, and especially because we have a mechanism for ex parte urgent application. So technically, if they're really, really urgent, you can just get it
Yes.
within a day.
This
Within
was
a day.
really fast. So.
Yes.
Sounds great.
I guess Sayed had something to say.
Yes, this is so if you can see the Indian jurisdiction, it is very quite easy to grant and to take the interim order from the courts before the arbitral tribunal will be constituted. But court will easily grant interim measures. But there is a clause that as Section 9, this is mentioned in Section 9 of Arbitration Act. So as soon as the Section 9 order has been passed by the court, you have to constitute the arbitral tribunal before 30 days, within 30 days.
Okay.
So as soon as tribunal will be created, then you have to file again the interim measures application before the tribunal in Section 17. Then arbitral tribunal will see whether they need to uphold that interim order passed by the court, they want to continue it, or they want to just, if they want to amend it, they have the power to amend that interim order also. But there is mandatory provision that you have to constitute and you have to start the arbitration within 30 days after taking the interim order from the court. But court will easily grant interim measures like to restrain the parties to create the third-party rights on some property, on assets, or freezing the bank accounts.
Yes.
Even they freeze like a very umbrella order. You have to like anything which is all the bank accounts, all your stock accounts. So courts easily give these type of interim orders in favor of the claimant. Even sometimes they pass the ex parte order also. Even before, on the same day, on the as soon as you file the application, court will pass the ex parte order and then give the other party to time to come to the court and submit their statement of defense. So it's very easy to take interim order from the court.
Thank you. In time, Karen?
I think that's the same in mainland China, because according to my internship in the law firm, that as for the domestic arbitration cases, we do have some cases that apply for the interim matter for the property preservation. That I remember almost every application for property preservation that we submit, most of them agreed by the courts, and it won't take a lot of time. So it's quite not that hard for Chinese courts to agree the interim matter.
Elaborate a little bit from India that this is maybe one of the reasons that if you can easily freeze, for example, a bank account, that automatically freezes the activity of the company. And our courts tend to follow this concept that if it is not, let's say, proved that there are grounds for freezing the activity of the company, which may affect very significantly business activity, then the court shouldn't issue the measure. So this is maybe the background of the
Attention, because it's interim measure, so it's
yes, exactly.
when I was in Hong
But I
Kong, I
think-
remember it was, they said like, oh, it's only for 30 days. We had to the amounts that we claimed that we
Yeah,
don't
that
have
was
evidence.
my issue, that whether it's possible to freeze this
It's not,
the exact amount, because this is also a problem of regulation. Because for example, in our country, we don't have a list of interim measures, so it's not fixed, it's not closed. You can, let's say, just find out something which might be probable and apply, but still it doesn't work. And that's why I wonder, because in some cases we're trying to issue some interim measures related to some exact amount. Even in that case, there is a problem. It's because there is a kind of typical of freezing all the account. And there is the issue whether it's possible to implement freezing partially, for example, in respect to those amounts which are the merits of the case. So, as I understand, in your jurisdictions possible, it's easily to receive the interim measures award just related to this exact sum, which is the merit of the case.
And I think that's still, firstly, I think there's still a balancing exercise in the sense that, like, usually when you ask the court to order a Mariva injunction to freezing order, they will usually require you to provide an undertaking or even a cross undertaking.
Yeah.
For the vacation, that's the first thing that you need to put something in before you can obtain the freezing order. But like in terms of like the exact amount, whether or not can freeze an exact amount, of course that would depends on how you frame your application. Like usually that would be the if you claim like 100 million, and then my claim is that I've been defrauded, then usually they would put an amount in the injunction order and then say freeze it up to the amount of 100 million. But of course, that is the legal side. But in terms of like enforcement, how the bank would view that, maybe some bank would say because of my internal due diligence issue or my internal regulation, something like that. When I receive this injunction order, although maybe it just say, oh, we'll injunct up to the amount of this, but maybe there is like many much more higher amount of money in that bank account. But maybe from the bank's perspective, in order to have due diligence or something, they may freeze the entire account, and that is possible. But of course, like I mean, as lawyer, maybe I can write a letter to the bank and say, oh, you can only enjoy these amount of money in your account, but not the other. Maybe you need to evacuate other sum. But maybe from the bank's perspective, they would have their own concern. Yeah, so not maybe not entirely about the court or something, but the bank is like thinking about that on my field. Yeah.
Thank you. So I think then with the Q&A, We are now moving to the debate about interim measures. And this is supposed to be a little bit more broad, but it was really nice question. Thank you very much. Thank you very much for your insights from your jurisdiction. I think everyone learned a little bit more. And thank you very much for the invite as well as to be the moderator. Hope to be made a little bit of honor to the table as well. Thank you very much. And I think